Yeah, no. Yeah, no.
May I please, Your Lordship?
Yes.
Your Lordship, may I mention item 11? We get to receive instructions, so we'll pray for 3 weeks, Your Lordship.
We'll see when the matter reaches.
Your Lordship.
For admission, item numbers 1 and 2.
May I please, Your Lordship?
Review.
I will bring on behalf of Vijay, he had personal difficulty to appear in person. I pray the matter be fixed on 9 April.
Your review. What is the review you are seeking?
Review our prayer for holding developmental promotion proceeding was not allowed in our review.
Is the petition pending?
Yes, my lord.
The petition is pending.
Yes, my lord, it is pending.
Then what is their review for?
Review
It will be subject to outcome of the petition.
2025, the departmental promotion posting was already held without giving chance to our petitioner.
Understood, sir. So if you are entitled to this, you are challenging what? Impugn ACR or area for the period from students. So we do one thing. On 9th of, when do you want?
On 9 of April.
9th of April. We try to dispose of the writ petition. We grant you the entire relief if you are entitled to. Otherwise, matter over. It's no point keeping the review pending out there. Review is against an order. These orders are always subject to the outcome of the writ petition. Don't you think that?
But since the junior to the petitioner were already promoted.
Understood.
So
So
prior-
therefore, it is only in the final relief given in the writ petition.
Yes,
I
my
can
lord.
pass the order. Don't you think so?
Yes, my lord.
So therefore, we keep this matter for final disposal on 9th of April.
Yes, my lord.
Whether that order, whatever order is passed, review, that order is always subject to the outcome of the writ petition,
Yes, my lord.
isn't it? Mr. So-and-so, the learned counsel appearing on behalf of the review petitioner submits that so-and-so who is leading the matter is not available today
Yes, my lord.
and therefore seeks for an accommodation. It is a prima facie opinion of this court that the review application so filed is against an order dated 24/5/2025. Full stop. Any order passed in the review petition, any order passed during the pendency of the writ petition is always subject to the outcome of the writ petition. in that view of the matter, this court is of the opinion that the instant writ petition be taken up for final disposal on 9th of April 2025, 26, list accordingly. Put it in the main writ petition.
For admission, item
Mr.
number,
Gauhati, you were appearing in this matter for the respondent.
Mrs. Muli,
Where is he?
I don't know.
Okay, inform him
Okay.
about this thing, that we'll take up the main writ petition for.
for admission, item number 3.
May please lordship.
What is the matter about?
My lord, in this case, two villages under Parent district, they are disputing over the land for the establishment of new district. Then compensation was already worked out for the two villages. Then yet to be paid. In the process, government wanted to go ahead with the executions of the shifting of new district headquarters. Then we disturbed little bit. Right? So then government called both of us. All right, two villages will give grade 4 appointment to one each to two villages in terms of policy 2018 government policy. So now after that, that was done. Now from the
This was done when?
2024.
How is it possible for giving posts? Now that isn't this set aside by the, isn't it the policy of the government in the year 2018 that there shall be no post
Correct.
reserved on land ownership basis?
There is a clause in that. There is a clause in that.
What
that
does it say?
If Lord, so what happened now? That over the land property dispute, still the civil suit is pending district court Dimapur. In the meantime, my landed counsel, my landed friend CT, he represents the petition in this case, has filed petition challenging my appointment. So subsequently, our village also have challenged the appointment of their village. So another petition is pending. So therefore, today, in the absence of my landed friend CT, if these two can be clubbed together, and
When do you want it?
can be because both can be heard together because out of same government approval.
When?
Lordship, hearings are not complete in the other
So,
petition. So
In that it can be
It is-
listed.
it is always the same. His writ petition and his your writ
Yes.
petition. Both are pleading.
It can be restated,
complaints and
Mr. Chairman.
complaints.
After 2 weeks.
after 2 weeks.
Right, 2 weeks?
Because
I
in
will
that-
be sitting.
No. In that case, the private respondent has not come. Otherwise, we have filed.
Who?
Private respondent in that
Yes, she's
case.
there.
No,
they are
I'm
not there.
a
They are not
party in
there.
the other
They are not
case.
there.
You are there. You are also a private respondent there.
Yes.
So you enter into your writ petition that you are submitting that this writ petition should be taken with that. Then obviously your presence is already there.
Only party will engage them. Till now, till date, it has not happened.
But how can there be in 2024 any decision taken that goes against the government policy of in the year 2018 that there under no circumstances there shall be appointment, and the 2018 policy only says that those which happen earlier,
Correct.
then only we are going to. But if it is a decision in 2024, it cannot. Where is that office memorandum?
My lord, the OEM was signed in 2006. Then land acquisition procedure was completed in 2009. According to the writ petition.
Where is that here? Yes, government, who is appearing? Is these type of things permissible?
Now,
Because
As far-
you categorically say in your office memorandum, which is holding the field, that there can be under no circumstances any appointment on land ownership basis post that 2018 office memorandum. If that be so, how can you have any understanding in the year 2024? Possible.
Lordship, it was happened because there was disputes
So-
between the two villages.
So therefore, You
So
have
in order
to go
to
against
reconcile
the,
lordship,
it is the
the state
government
has
decision.
appointed lordship,
Office memorandum is the government decision.
no lordship.
So can the district administration go against it? Difficult. Anyways, it has been submitted by Miss Madam, your name, you are appearing for? The
Petitioner.
Petitioner.
Submits that the instant writ petition is connected with another writ petition with
WPC 221 of 2025.
2002-1/2025. And therefore submits that both the writ petitions be taken up together. So taking into account the above, lists this matter again on when? 25th, 26th March.
I have some difficulty.
What difficulty, Mr. Joe? You are there. I will see you here appearing in other matters on 26th. If you have personal difficulties, you take it there today. You kindly note it down that Mr. Joe has personal difficulties on 26th. So any matter he appears on 26th, then I will adjourn it.
My lord, I have in Dimapur. 26, I have one matter, civil matter in Dimapur.
Okay. 24th,
Why?
on 24th of March.
For admission, item numbers 4 to 7.
My pleasure, lordship.
Yes,
Lordship, I believe to receive instruction from the main respondent, that is the respondent number 1, lordship.
Huh?
I believe to receive instruction from respondent number 1.
you've got your instructions?
Lordship, for BNR, I have received lordship. So if sometime we granted to file lordship,
You have taken so much time filing affidavits. 19 to 1/5/2025 notice was issued. You are retired?
Lordship, only one is in service, Lordship. The 4 and others matters, Lordship. The first one is
Item numbers, this one, 69 of 2025.
Retired.
Person must have been
Lord.
retired. Because you otherwise retire at, if you complete 35 years,
Lordship.
you retired there.
Yes, Lordship.
So now what do you want? Regularization?
Yes, Lordship.
Because you were not taken into consideration at that point of time.
Lordship.
But that is dependent upon the post being vacant. This comes under 17(3).
If it comes under 73, Lordship, the
What posts are these?
grade 4 post, Lordship,
Understood. What type of appointment?
sweeper, Lordship, contingency, and
Contingent.
subsequently converted to casual basis, Lordship.
Contingency.
Yes, Lordship.
Contingency is not covered under 17(3).
Contingency, Lordship, by a subsequent notification in the year 2025, 5th March 2025, Lordship. 3 categories of employees are also included under the 17 March 2015, Lordship. Lordship, I also passed a similar order, Lordship. On 4th April 2025, I have enclosed in the petition, Lordship. Page number 40, Lordship. WPC 316. Page number 40 of the first reflection.
316. Huh? I have. In which case you have?
69, WPC 69, Lordship. Page number 40. And this order was passed in WPC 316 of 2023. Page 40, Lordship.
Yes, why can't we pass the same order?
lordship, the petitioner case is not covered, has matter notification dated 5/3/2025.
No, I am not.
There is no mention about any
Madam,
retrospective, lordship,
I am not asking you to give him appointment.
lordship.
See the order which I have passed. Paragraph 6, page 43. The instant writ petition stands disposed of, thereby directing the respondent, more particularly respondent number 3, to take effective steps for the purpose of consideration of the case in terms with the notification dated so and so and the office memorandum dated, and the same be preferably within 4 months. Well, what is wrong? You have to consider
Lordship,
whether he's entitled or not, how much when the person is retired.
Lordship.
See, don't you feel a bit agony for not only the petitioner to Mr. Muajomi also?
Lordship,
They pass the same order.
Lordship, the petitioner is on scale bill. However, Lordship, the petitioner scale bill is irregular, Lordship. Yes, irregular, Lordship.
Irregular.
Lordship.
So take while passing that order, while considering, take that. Instead of taking time for filing the affidavit, I'm asking you to consider. You consider it. Say that it is irregular, so the petitioner would not be entitled to. Why are you not doing that?
Lordship, this-
I'm not passing a direction to the fact that he is entitled to give it to him. This is not the direction which I am going to pass. I'm going to pass this order to consider his case. Now, once you do it, then the ball starts moving. Now, here taking time from 2025, we are almost 1 year taking time for filing affidavit. That
Lordship.
Lordship, since I have received an instruction from the BNR, so Lordship sometime will be granted to file affidavit. Lordship.
same thing will happen again. If you file your affidavit also, can I pass an order to that effect that don't consider him? He is only asking for consideration. She submits, she says that, look here, I've completed 35 years of service. Now, I am going to retire or have retired now. Because of that Nagaland Act, Public Employment Act, that one has to retire either 35 years or process 60, whichever is earlier. Now, here I have completed 35 years. At the time when I was there, the government had come with a notification, office memorandum of 5/3/2025, that they are going to consider those persons. Consider my case. And they have not considered, therefore I am here. This is the case,
Lordship.
long and short.
Since Lordship, as per the instruction, as per the ROB 1999, the petitioner, although he's in scale pay, however, Lordship, he's irregular, Lordship. Lordship, I can
Understood. So, put that, reject his case on the basis that he is irregular. Why you are asking this court to decide that he is very irregular or she is very irregular?
Lordship.
And as such none. You have, I'm giving you the entire plate. Look here, take it. Now you are saying that no, you kindly choose which apple you want to give it to me. I'm giving you an entire fruit basket. Take apple, kindly give me that apple. You're asking me. I'm putting the entire thing ball to your court. Yes, madam. What better advice are you giving to your colleague?
If sufficient time will be granted, Lordship. Sufficient time will be granted, Lordship.
Huh?
If sufficient time will be granted, Lordship.
You consider his case. I have nothing to do out there. I'm saying that kindly consider, kindly see. What is the office memorandum? Inclusion of here. In exercise of power, the Nagaland so and so hereby notified all contingency fixed base so and so appointed on or before 6th of June 2000 year shall be deemed to be casual employees and henceforth come under workshop and shall be eligible to the schemes and provisions so notified under the provisions of the Act. A verification shall be conducted on the direction of the Workshop Commission. The employees so verified shall be eligible for regularization under 1 and 3 of so and so. So consider his case. We dispose it of. Passing symptoms.
Lordship.
Okay.
Lordship.
All you are appearing in all the cases, petitioner.
Lordship, all the four
Okay.
cases.
Mr. Mohammed and counsel appearing on behalf of the petitioners. Petitioner in the batch of the petitions. Ms. So-and-so appears on behalf of the state of Nagaland. Whoever appears for what, give it to her. She appears for the state of Nagaland. The present batch of writ petitions have raised common issue. The present batch of writ petitions, the facts in the present batch of writ petitions, the issues involved in the present batch of writ petitions being similar, the same are taken up for disposal by this common judge with an order. This court, however, finds it very pertinent to take note of the brief facts which led to the filing of the four writ petitions, filing of the present batch of four writ petitions. Then you put heading WPC number 69/2025. The petitioner herein was appointed as a sweeper on casual basis under the office of the Assistant Public Prosecutor, Junabeto, Nagaland, at a fixed pay of 450 per month, via an office order number AF/GE-1/81 dated 26/7/1989. Thereafter, by another order dated 27/9/2017, the petitioner was appointed to the post of Chokidar cum sweeper in the office of APP, Junabeto, on casual basis for a period of 1 year with effect from 1/10/2017 in the scale of pay of rupees 2250-26,2660-60-3200 under ROP 1999. The petitioner submitted a representation on 6/11/2023 for consideration of a case for regularization, taking into account that the petitioner had completed 34 years of service. By an order dated 26/11/2024, the Undersecretary to the Government of Nagaland communicated to the petitioner in reference to her application for regularization of service, conveying the inability to regularize the petitioner's service in view of the observations and comments made by the PNR department dated 22/10/2024. It is the case of the petitioner that the petitioner is entitled for being considered for regularization in terms with the office memorandum dated 17/3/2015, taking into account that the petitioner was granted the scale of pay and have rendered more than 30 years of service. As on 27/7/2019. It is the further case of the petitioner that by an office memorandum dated 28/8/2024, the PNR department revised the procedure for regularization of work charge and casual employees. Further to that, by another office member in a notification dated 5/3/2025, the PNR Department of the Government of Nagaland have included contingency fixed and wage paid employees as casual employees under the Nagaland Work Charge and Casual Employees Regulation 2001. It is therefore the case of the petitioner that the petitioner should have been considered for being regularized, as she has rendered more than 35 years of age, 35 years of service, as on the date of filing of the writ petition. 82. WPC number 8. Then you put 74. The case of the petitioner herein is that the petitioner was appointed on contingency basis as a typist by an office order number LAW-115/81-3 dated 13/8/1991 under the office of the Assistant Public Prosecutor Mokokchung, Nagaland, on monthly wage of ₹540 for a period of 3 months with effect from her date of her joining. Subsequent thereto, on 27/9/2017, the petitioner was appointed to the post of typist under the establishment of the public prosecutor, Mokokchung, on casual basis for a period of 1 year with effect from 1/10/2017 in the scale of pay of ₹30/3950-75/80-4590 under ROP 1999. It is the case of the petitioner that the petitioner had submitted a representation on 8/2/2024 for regularization of her service. The same having not been done, the petitioner has approached this court by filing the instant writ petition. WPC number 82/2025. The case of the petitioner herein is that by an office order number LAW/JE/10/87 dated 4/3/1989, the petitioner was appointed as a contingency paid sweeper under the office of the Additional Deputy Commissioner (ADC) Waka, Nagaland at a fixed pay of ₹450 per month, payable with effect from 1/2/1989. Subsequent thereto, by an order dated 27/9/2017, the petitioner was appointed to the post of sweeper under the establishment of the District and Session Judge, Waka, on casual basis for a period of 1 year with effect from 1/10/2017 in the scale of pay of ₹2250 55,-2660-60-3200 under ROP 1999. The petitioner thereupon submitted a representation. When did you submit the representation?
Representation is dated nil, Lordship.
Submitted a representation seeking regularization. The same having not been considered, the petitioner has therefore approached this court by filing the present writ petition. WPC number 104/2025. The case of the petitioner herein is that the petitioner was appointed by an office order number ADC-J-TSG/EST-2/1993-94 dated 1/10/1993 as a chokidar on contingency basis under the establishment of the Assistant Deputy Commissioner Judicial at Tuangsa, Nagaland at a fixed pay of ₹450 per month. Subsequent thereto, by an office order dated 10/11/2022, the services of the petitioner was extended up to 30/4/2023. The petitioner further states that his service was further extended till 30/4/2024. The petitioner having completed 30 years of continuous service on 30/9/2023 and enjoying the scale of pay. Claimed that the petitioner is entitled to be regularized. In that regard, the petitioner had submitted a representation. Have you submitted?
Lordship, in this case, that no representation, Lordship.
The petitioner, however, was expecting that the petitioner would be regularized in terms with the office memorandum dated 17/3/2015,
Lordship.
taking into account that the petitioner had completed 30 years of service and was also granted the scale of pay. It is under such circumstances the petitioner has approached this court by filing the present writ petition. This court have heard a perusal of the records after that. A perusal of the records of the present writ petition shows that this court have issued notice almost 8-9 months back in all the 4 writ petitions. The respondents have not filed any affidavit in opposition. It has been brought to the attention of this court that this court have passed and the issue involved in the present writ petition is covered by the order passed by this court dated 4/4/2025 in WPC number 316/2023. This court also finds it very pertinent to take note of that in terms with the office memorandum dated 17/3/2015, all existing work charge and casual employees of various departments who were enjoying scale of pay and who have completed 30 years of service, years or more continuous service as on 1/1/2015 would be regularized by conversion of their post into regular ones personal to them and subject to fulfillment of conditions as indicated in the said office memorandum. It is also pertinent to take note of that in terms with clause 3. Pertinent to take note of that in terms with clause 1, Roman 2, of the office memorandum dated 17/3/2015, those work charge and casual employees in scale pay and who have completed or will complete 30 years of continuous service after 1/1/2015, their cases for regularization would be taken up subsequently in 2 batches. That is, on 1st of July and 1st of January every year.
Lordship.
It is very relevant to take note of that the said office memorandum dated 17/3/2015 only related to regularization and absorption of work charge and casual employees and their revision of pay/wages.
Lordship.
However, subsequently, by an office memorandum dated by the
5th March 2025,
where is that document?
page 39 in the first writ petition of WPC 69.
By the notification dated 5th of March 2025, all contingency, fixed and wage paid employees appointed on or before 6th of June 2016 were deemed to be casual employees and hence would come within the ambit of the office memorandum dated 17/3/2015. this court finds it very pertinent to take note of. This court finds it for the purpose of the present adjudication, the notification dated 5/3/2015 is reproduced hereunder. Next. Taking into account that all it is also very relevant to take note of that another office memorandum was issued dated 5/3/2025, whereby all work charge and casual employees in all departments whose names have been duly verified in the district level verification committee and registered in the PIMS, receiving fixed pay was held to be granted would be granted the scale of pay as per the revision of pay 2015 with effect from 1/4/2025. The said office memorandum being relevant is reproduced hereunder. Madam, this is at page 42. In view of the office memorandum, a notification dated 5/3/2025, as well as the office memorandum dated 5/3/2025, as reproduced herein above. It is the opinion of this court that as the petitioners herein have already completed more than 30 years of service, the cases ought to be considered as to their entitlement for regularization in terms with the office memorandum dated 17/3/2015 read with the notification as well as the office memorandum dated 5/3/2025. Accordingly, the present batch of writ petitions stands disposed of with the following observations and directions. Number one, the petitioners in the present batch of writ petitions, the respondent authorities, and more particularly, the respondent number 2. I think 2 will do.
Lordship.
Respondent number 2, Commissioner and Secretary, Government of Assam. Respondent number 1 and 2. Respondent number 1 and 2 are directed to take effective steps for the purpose of consideration of the cases of the petitioners in terms with the office memorandum dated 17/3/2015 read with the notification and the office memorandum dated 5/3/2025. Number 2, the same be done within the said exercise be the said exercise be carried out within a period of 4 months from the date a certified copy of the present judgment is served upon the respondent number 2, that is the Commissioner and Secretary to the Government of Assam Personal and Administrative Reforms Department, Nagaland. There shall be no order of post.
Obliged, Lordship.
You are appearing for whom?
I'm appearing for
Government?
Respondent 5 and 16 WPC 82 2025 on behalf of my senior A.Z. Momi,
No.
standing counsel
What is 5 and 6?
Gauhati High Court.
for Gauhati High Court.
Oh,
Give you obligation.
For admission, item number 8.
wait, in respect to the Gauhati High Court, There's only one case at Gauhati High Court. Where is that counsel? Mr. Muajami, how many cases are there for the Gauhati High Court?
Only one lordship, in respect of WPC number 82.
Madam, you do one thing. 3 writ petitions, you make one order, and 1 writ petition, you make the other one. The Gauhati High Court make it separately, and then the respondent, item number 82, na?
WPC 82 of 2025. lordship.
So here the directions will be given to the respondent numbers 1, 2, 5 and 6, 4, 5. 4 and 6.
Lordship.
4 and 6. This direction which is given, earlier I gave the direction to 1 and 2. Now here in this case will be 1, 2, 5,
5 and 6.
4 and 6.
Lordship. Obliged, lordship. For admission, item number 80.
What is this?
What's been
Who has filed the IA?
Lordship, I have filed the IA, lordship. I'm representing the SBI, lordship. However, lordship, they have engaged a different counsel, Mr. YP Kofta, lordship.
Why have you filed the IA?
IA for vacation of the interim stay, lordship.
What stay?
Stay was granted for the operation of the bank account, lordship.
Huh? Just let me see. What is the order passed? Mr. So-and-so, the facts of the projected by the years figure regular and business have been unknown for now, however, due to financial concerns, are defaulted in payment. Repeat that against the defaulted loan, the respondent bank, the date of requirement of the head attached to along with the pension beneficiary was the deduction of yes. Are you?
Lordship,
I think we should vacate it.
Lordship, I was told that they will withdraw and then new counsel has been engaged.
Not necessarily. Other side counsel is there. Mr. Muajami is there. You agree on their point. How can there be allowing you, on one hand, you don't pay the dues, you default. And how can you see, normally pension cannot be attached as per section 60 of the CPC. But the moment the pension amount comes to the bank account, it can be attached. That's the law. So, are you that case?
Lordship, I'm appearing on behalf of my senior NDMR. Today he has some personal difficulties, so
When is he
can be
available?
fixed on tomorrow, Lordship.
Okay, tomorrow. We get this type of order. In fact, the petition should be dismissed. We dismiss the petition tomorrow. Ask your senior. Tell him. Okay? At the request of the learned counsels for the petitioner, matters sent adjourned. Take care of tomorrow.
Obliged.
Lordship, interim may be can be extended till tomorrow.
Interim order passed earlier shall continue till tomorrow.
Obliged.
For admission, item number 9.
Please, Your Lordship.
Yes.
Lordship, on behalf of Sir Im Dim Song, here we are yet to receive instruction to file affidavit in reply.
What is this IA business?
It is IA for stay. Stay is already been granted. IA is for stay, Your Lordship.
Day of what?
Stay of order dated 28/5/25. Issued by the Deputy Secretary, Government of India to the Home Commissioner, Lordship.
Then?
As per this notification, Your Lordship, no new indigenous inhabitant certificate should be issued to the 4 tribes. That is the petitioners, Your Lordship. So this has been stated, Your Lordship.
What is the interim order passed?
By order dated 26/6/25.
There is already a stay regarding the exercise and enumeration in the minute. It is ordered that the operation of so and so contained by the daily earning. What is this case?
Lordship, here the petitioners are aggrieved by the enumeration process, Your Lordship.
What is this?
For issuance of indigenous inhabitant certificates, which is targeted only to the 4 tribes, Lordship. That is Garo, Kuki, Kachari, and Mikir, Lordship. Now, Lordship, these 4 tribes are also recognized tribes of the state by an act of parliament, Your Lordship. Now, the state respondents are trying to change the status, Your Lordship.
Who?
The state respondents, Your Lordship.
How?
Lordship, if Your Lordship may kindly come to the impugn order, Your Lordship,
Let us see that impugn order.
at page 102.
Register of Indigenous, the cabinet discussed and approved the draft notification containing eligibility criteria for being an indigenous inhabitant of the state of Enumeration in Independence year. Directed to the Home Department of this article.
Now, Lordship, here there is a format
But Madam, tell me,
prescribed, Your Lordship.
tell me
104.
amongst all your tribes, how many tribes are there in Nagaland?
There are
9? How many?
19. 19.
90.
Yes, sir.
Now, what was the kingdom of Dimapur? Under whom?
Ahom, Your Lordship.
No, Kothari.
Yes, Your Lordship.
Then that's the Kothari kingdom. That's Dimapur. And they are one of the tribes, main tribes of yours, isn't it? While
Yes, Your
visiting
Lordship.
Hornbill, we see them.
Yes, Your Lordship.
Then they also have a Murum.
Yes, Your Lordship.
Then what is your objection?
No, Lordship, if you kindly come to the format at 104, Your Lordship. Now, the criteria. Actually, there were 3 criteria, Lordship. Let me take Your Lordship to the real 1997 notification.
They have put a cutoff date of 63.
Yes, Your Lordship.
The 63 date is being put because Nagaland state was formed.
Yes, Your Lordship.
So those people who were prior to that date of formation and they were inhabitants out there, they are being given
Lordship, kindly come to page 62. Page 62.
32,
62.
62. Yes.
Now here, this is the criteria for issuance of IAC, Lordship. There are 3 criteria, Lordship. 1, 2,
His
and
or
3.
her parents legally in the case of person was then a minor should have entered in the electoral roll published on 5/12/1963.
Yes, Your Lordship.
So
And
then-
number 2,
No, you see, the governor of Assam is pleased to decide that in order to qualify as indigenous here,
yes, Your Lordship.
state of Nagaland for the purpose of as engaged in so and so, a person should have settled
Yes.
permanently in Nagaland prior to 1/2/63.
Yes, Your Lordship.
The following shall be given. So these are all four.
Three criteria.
The first one,
Only,
the first one,
yes, Your Lordship.
what does he say? His or her name
Yes.
of parents or legitimate guardians in the case of person was then of a minor should have been entered in the electoral roll published on 5/12/1963.
Yes, Your Lordship.
Now let's come to page 104. Not 104, 101. The cabinet discussed and approved the draft notification containing the eligibility criteria of being an indigenous of the state and issuance of indigenous habitant certificate. Further, the cabinet directed the Home Department to immediately start enumeration of Kochari, Kuki, Garo area who is and settled in the state prior to 1 year.
Yes, Your Lordship.
So
That's why at
even-
first glance it looks fine, Your Lordship. But if Your Lordship will come to the format, enumeration format as page 104. Now here, the criteria is reduced to only 1.
What?
The sole criteria is inclusion in the electoral law of 5/12/1963.
Serial
That
number?
is the Lordship, serial number 2, Lordship.
Name
Name
of
of-
a person whose name has been entered in the
Yes.
electoral roll published on so and so.
So that is the only criteria now.
Ah.
There are 3 criteria, Your Lordship. Those who doesn't fulfill the other 2 criteria, if they fulfill, they will be issued the IAC, Lordship.
Person his or her parents or legal guardians should
Yes,
have been
Lordship.
paying house tax prior to so and so.
If Your Lordship may come to 62 again, Your Lordship.
Person, no, that is what the person or his or her should have acquired property and patta on it prior to so and so. So you are in favor of there should be more people.
Lordship,
Or are you in favor of there should be less people?
no, Lordship, page 62.
Hmm.
Page 62 is the prescribed, there are three criteria. If
Yes.
one criteria.
One is
if
voters
is not
list.
met, if 2 or 3 is met, then ISA will be issued. Now.
They
from
have
this-
reduced it only to
Only
electorate.
one. Now, the point of note is that many of the tribunals of these 4 tribes, including the Naga tribes, they don't have their name enrolled in the
Voters list.
Yes.
Oh.
So for those persons whose name are not enrolled, the other two
But
criteria,
Other
yes,
criteria have not been.
yes. Now also, this is only subjected to
No,
these
I
4
got your
tribes.
point.
Yes.
Lordship, I have not been instructed by our additional AG, so I'm just seeking the time.
No additional AG.
No, today he's in leave.
Tomorrow? Is he in leave for how many days? 2 weeks.
Since we have not received instruction of the Lordship,
Come up with that.
that's why.
Next week, Monday.
Monday, Lordship.
Next Monday.
Lordship, after 2 weeks,
No, next Monday. It's a very old matter. There's a stay. You see, it is not in the interest of yours also. Get your instruction to that effect as regard this and ask your additional AG or AG to appear. This is a matter of very big importance. There's a stay making. If you keep on staying it, if the proceedings is stayed, there are a lot of people who are also being deprived. And there are also the person who are not getting certain certificates. So this needs to, you have a cabinet decision. I think this cabinet decision has to be, the cabinet decision, normally you cannot challenge it. It is only the consequence of a cabinet decision. If it is illegal, then you can. Now, this is a notification. Now, whether this notification of 1977 had 3 categories. First, those who had electoral rolls. Second, those who had their patta.
Yes.
Or third, those who had paid house tax. So now patta and house tax is out, only electoral roll has been given. So you are only giving the importance to the ECI and not to your people. Simple. What do you say, Mr. Angami? Isn't it simple? Her only question is this, that look here, another 2 persons are there. And now they have also put it less, you see. I don't think now, madam, one thing, you also look into another aspect, very important. This will only be in the case of Kosari, Kuki, Garo, Mikir.
Yes, Your Lordship.
But this is for all. See, page 62 is for all.
All, Your Lordship. All the
Now,
recognized tribes, Your
here,
Lordship.
they, for Kosari, Kuki, Garo, Mikir. Garo is it a scheduled tribe in
Yes,
Assam?
recognized tribes. So.
No. Is it in the scheduled tribe order
Yes.
of 1950
Yes, Your Lordship.
recognized for the state of
Yes,
Nagaland?
Your Lordship. Page 38, Your Lordship.
This is done under 342.
Yes. 38. Yes, this is the one. At page 39 is the tribe listed, Your Lordship.
Oh, they are there.
Yes.
Naga, Kuki.
The remaining
Naga means everybody.
2, 3, 4, 5 is the petitioners, Your Lordship.
Huh?
It's at page 39.
Kosari, Mikir, Garo.
Yeah, these are the petitioners, Your Lordship.
So these people may have left. So therefore, they have mentioned about this. Naga, there is no problem. Everybody will
Yes.
get it. But if these 4 are there, they should. And they have filed affidavit.
still yes, Lordship.
Oh, what instruction is required? I don't
Read
know.
the island.
File one
Have
additional.
What is the affidavit? What do they say? Why they have not done it? Let us see. Maybe ensuring the prevention to safeguard and protect the soils of the indigenous and considering the environment of policy was taken in the criteria was a substitution. So indigenous and such vested right to bypassing them. Now, what do you say about paragraph number 8 of the affidavit in opposition?
My apologies, Your Lordship. I don't have that copy right now.
Oh, have a look. Give a copy of the affidavit. You have not been given.
They have given up.
And you have filed reply also.
Yes, Your Lordship.
You have the reply, you don't have the affidavit. Finally, see paragraph number, two paragraphs, 8 and 17. Paragraph 8 says, it is submitted that the impugned instruments are in continuation of the earlier policies. It is not in substitution or in derogation or in abrogation. It is in continuation. If it is in continuation, that will still hold the field. Then paragraph 17. The cabinet merely reiterates the issuance of so and so to four-year those who are settled in the state of Nagaland prior to so and so. Besides, the order dated so and so does not take away the status of the petitioner as a recognized tribe of the Nagaland. It is further reiterated that the enumeration is mainly to maintain proper records of genuine indigenous those who settled prior to so and so.
But the format.
More so, the enumeration exercise rather than revision of the identity of the so and so. So this
But the
takes care
format
of.
says otherwise, Your Lordship. The
No.
format says otherwise, Your Lordship.
No, we will have the additional advocate general next time
Yes, Your Lordship.
and get it said from their mouth
Yes, Your Lordship.
that this is in continuation.
Yes, Your Lordship.
Once it is in continuation, that 77 will still hold the field.
Yes.
Matter is over.
Yes, Your Lordship. Monday, Your Lordship.
You don't require anything. This is your stand.
Lordship.
Mr. So-and-so appearing on behalf of the respondent state submits that the matter is he's being led in the instant matter by who?
Im Song Lordship.
Im Song, the learned additional AG. And it therefore submits that some time may be granted today. Without taking into account that there is an interim order passed, it is the opinion of the court that the said interim order, that the instant petition requires an urgent disposal. Accordingly, list this matter Monday.
Lordship, the interim orders passed in the IE as well as the petition.
Final disposal. For final disposal, interim order passed here shall continue till the next day.
No.
For admission, item number 10.
Yes.
Like this, Your Lordship. Lordship, I'm appearing for respondent number 8. I filed this Vakalatnima this morning only. Kindly allow me 2 weeks to file the affidavit in opposition.
Today morning only.
Yes, yes, Lordship.
Government has filed.
We have filed with
Oh.
However, I have.
You are a
appeared-
beneficiary.
Lordship, here it appears that after I filed my affidavit, statement has been inadvertently made. So I seek the leave of this court to file a corrective affidavit, Your Lordship.
Additional affidavit.
Yes.
Why? What have you done?
Para 5. In my para 5, affidavit in opposition.
When they continue upon the appointment.
The nature of agreement of the petitioner is probation. However, we have stated that it is on a stopgap arrangement.
So which is the next.
Sub-para.
Stated the existing government policy also given. Is they have no alternative but to terminate the service with the Now, what do you want to say?
So here we want to make a correction that it was not on a stopgap arrangement. His appointment was on probation, as per the record. So
Probation.
yes,
Ms. Esme,
yes, Mary.
the line counsel appearing on behalf of the state respondents submits that there is an inadvertent error in paragraph number 5 of the said affidavit in opposition, wherein it is being mentioned that the petitioner was appointed as on a stopgap arrangement. Rather, the petitioner was appointed but was under probation.
Yes.
She therefore submits that the said aspect would be clarified by filing an additional affidavit. Ms. So-and-so appears on behalf of the respondent number 8
Yes, Lordship.
and 6, 2 weeks' time for filing the reply. Who's to list this matter again on 6th of April 2026. In the meantime, the additional affidavit be filed on behalf of the state, clarifying the stand taken at paragraph number 5 of the affidavit in opposition. The respondent number 8 shall also be at liberty to bring on record its stand by filing the affidavit on or before 2nd of April 2026.
For admission, item number 11.
Please, Your Lordship.
Where is this case? Was
Sir,
impugn appointment order 2019 challenged in 2025. Why?
19 years.
Why?
Lordship,
After a person has been working for 6 years, why on earth you want this court to do all such things? Why were you sleeping?
yes, Lordship, there's the petitioners approached the Samdul Court after 5 years only.
6 or 5 years. Why?
Lordship,
6 years, 6.
no explanation has
2025.
been given the petition, but maybe they
I think on latches we should dismiss.
Sure.
What is the illegality? You have to tell me that this particular person is not eligible. That particular respondent. Why after 6 years he's been working? Why should we interfere?
Lordship, to the inadvertently, I have not brought my brief.
Okay, give him the
So,
blue file. Take that. Tell me. I don't need to go inside, but my question is, after 6 years, why should we interfere? Blue file, blue file. This is the yellow file. Give him the blue file. The second file.
yes. Lordship, I've got the second.
This is the second file.
Yes.
Okay. Why should we interfere?
Lordship, because the evidence is that the private respondent has been appointed without he's not a landowner.
So what? He is a
And-
landowner.
and the landowner has not been
landowner.
appointed.
Have you no? Tell me. Have you approached the authorities? You have not approached authorities. You are asking for a writ. You are asking for a writ. You have approached the year representation. Representation given in 2019, and then you wake up in the year 2000. Formally to say that so and so is the landowner of the property on which the newly constructed Satupuri health center apartment is. Viridkam confirms it. This is where so and so. Then, and what is your stand as regards the? Have you inquired about this representation?
Yes, Lordship. Lordship, I have not received any instruction as such as yet from the.
Obviously, they must have lost all the papers. 6 years, old matter, isn't it?
Lordship, let me come after a week or two, Lordship.
No, I think we should dismiss it right away.
Lordship, Lordship, today I'm not prepared, Lordship. Maybe gracious enough to lend some time, Lordship.
Your case reminds me of two persons. One is Kumbhakarna. Kumbhakarna, do you know who he is? This person is, this is on this, what do you call, Ramayana. There is Ravana's brother, who used to sleep for 6 months. And then he used to wake up. So this is one. But I think Kumbhakarna is better suited here than your petitioner. You may come nearby to another person. His name is Rip Van Winkle. Have you heard of him? What happened? This person concerned, prior to the American Revolution of 1789, he went to the forest and he went to sleep. Then he came back after 22 years. American Revolution, wife gone, everything changed. Earlier it was British, now everything has changed. I think you come nearby to him. I think we should dismiss it.
Lordship, maybe this is not, grant me some time. Please.
Monday
Lordship,
dismissal.
Lordship.
Okay. This court, while hearing the learned counsel appearing on behalf of the petitioner, inquired as to why the instant writ petition should be entertained, taking into account that the petitioner has approached this court after a period of 6 years from the date of appointment of the private respondent. Full stop. The learned counsel appearing on behalf of the petitioner submitted that he would like to look into this aspect and would address this court on Monday next day. List accordingly.
Lordship.
For admission, item number 12.
May it please, my lords. I appear through VC in this matter.
Why?
My lord, today actually,
You are too busy in Gauhati.
my lord, because the client does not have the means to arrange for the travel, so I could utilize this facility which has been provided by my lords.
So
I apologize for my inability to be physically present.
must be
there.
charging your client a lot, must be the reason why. What are you challenging?
My lord, here I'm challenging the termination that
You have been terminated.
yes,
in
my lord, I was
2014.
awarded a tender and I was terminated without following the procedure under the general conditions of contract, which according to them had governed the agreement.
What is your agreement?
My lords, my agreement is at page number 26, my lord. It begins at page 26. And the relevant portion, my lords, would be at page 32.
Agreement for what?
My lord, this was an agreement for removal and disposal of garbage from Dimapur railway area for 2 years, my lords.
Then
And that,
no, Mr. Borua, tell me, why on earth this writ petition? Why should we pass an order in a writ petition? It's a case of breach of contract. If it's a breach of contract, go to the civil court. Why on earth should we exercise 226?
my lords,
Is
because
the reason why your client has not asked to come to the courts? Why should I spend unnecessary money?
my lord, in this matter, I have to candidly admit, my lord, because I think the last correspondence that had happened with the railways was in the year 2022, my lords. And after that, we have been orally communicating with the railway authorities, but since there is no written communication.
No, Mr. Borua, tell me. Your agreement was up till 2016.
My lords. Yes.
We cannot now pass a writ to hold it that you are still to be allowed to continue. That would be against the purview.
Yes, my lords, that is not my prayer.
Not purview. The second is you are asking for damages.
My lords.
This is absolutely within the realm of the contract.
My lords,
It's a breach of contract. It will come under section 73 of the contracting. And if it is quantified 74, but under no circumstances, this court under 226 can is for withdrawal or dismissal, whichever it is. I give you both, either.
I'm so obliged, my lords.
Mr. Yagavati,
Yes.
should we dismiss or allow him to withdraw?
This is up to them.
No, I asked. Because if it is
In fact,
it is okay, but
this should be dismissed.
and if it is dismissed, I think
Yes,
dismiss with
they have disposed of the garbage on two occasions already. They have completely stopped. So see, for weeks the garbage has been collecting. So the dirt basically is my knowledge kind of factory. Even for one day, if you don't remove the dirt, but if for weeks and only if you don't throw the garbage.
Mr. Yangavati says that he is going to have a counterclaim.
I have already filed my.
What? Counterclaim?
Yes, my affidavit.
See? This
So my lords, they have filed an affidavit in
we are
opposition.
civil court now.
Well,
Claim, counterclaim, everything is here.
they should have gone to civil court lawsuit.
My lords, if I may just submit one thing, my lords. My lords, here we are not seeking damages. We are only seeking that whatever earnest money and performance guarantee have been forfeited from us, that may be returned to us because the termination was illegal process.
No, Mr. Counsel, it is a case of termination.
Yes, Lordship, they have not performed the contract.
Termination, this court has to hold that the termination is illegal. One.
Yes.
And they say that they are doing so because of the fact that you have not carried out any work. So therefore, the best option is, and you have filed this after.
Yes, my lord. That I'm candidly admitting, my lord. That after 2022, there is no written communication that we have. My lord, my only contention here is that they have the power to terminate it, my lords. But if they don't follow their own general conditions of contract, where I'm required to be served with 3 notices.
Why should this court allow a thing which is dead in the year 2016 to be brought up and give some little bit of flame by even issuing a notice? You were lucky enough somebody issued a notice to you. Well, I think this is a dismissal. Mr. Daya, we should dismiss it. And how much cost? I should impose some cost on you.
Because Lordship, I will leave it to you.
Whatever is your fees and
Yes,
whatever
Lordship.
filing, that shall be the cost.
Because my consideration, they have
We put it at 50,000?
50,000 is also very less because they have taken the contract. In fact, I'm just saying, just because when the contract was, they have not disposed of them, so we have to engage private parties to dispose of them during that time.
No, Mr. Ingoti, that is not the question.
Yes, that is not the question.
My question is the cost for filing unnecessary with petitions for which you had to be engaged. You had to file pleadings for that. 50,000.
It's quite reasonable, Lordship.
My lords, I apologize for that, my lords. The only thing that I thought would persuade my lords is the matter in which it was terminated.
No,
If my lords is not inclined, and I'm obliged
the
to that.
thing which have already, a thing cannot, this type of repetitions can't be allowed. Yes, you should have come immediately thereafter.
Yes, my lords. That I bow down to my lords, my lords. I have told the client the same
Let us
thing.
dismiss something in the morning today. Heard Mr. Abulwa, the learned counsel, appearing on behalf of the petitioner. Mr.
No,
Yudhawati
what
appears on
response?
behalf of the respondent numbers 1 to 4. The petitioner herein have approached this court. The petitioner has filed the instant writ petition challenging the termination notice dated 28/10/2014, as well as the letter dated 24/2015 issued by the Chief Medical Superintendent, Langding, Northeast Frontier Railway, for forfeiture of the earnest money and performance guarantee, and further seeks for a writ in the nature of mandamus, thereby directing the Chief Medical Superintendent, Langding, Northeast Frontier Railway, to refund the performance guarantee of rupees 44,664 and earnest money of rupees 19,330 by along with payment of rupees 1,46,600 for the works done by the petitioner, which were raised before the CMC Langding, by bills along with various other expenses as enumerated in the letter dated 12/3/2015. The brief facts which led to the filing of the instant petition are that on 3/4/2014, a tender was issued for removal and disposal of garbage from the Dimapur railway area for a period of 2 years from 1/7/2014 to 30/6/2016. Pursuant thereto, the petitioner herein was granted the contract The materials on record show that was granted the contract on 25/7/2014 for a period from 1/7/2014 to 30/6/2016. The record reveals that on 25/7/2014, a notice was issued to the petitioner informing him that in spite of the agreement entered into on the same date.
Yes, my lords, on the same date of the issuance of agreement. And this was the second termination, second notice, my lords. The first notice was issued even prior to entering into the agreement with me. My lords will have it at page 25. That is dated 9/7/2014.
On and it is further relevant to take note of that on 9/9/2014.
9/7, my lords.
Now there is another one, 9/9.
Yes, subsequent. Yes.
The petitioner was informed that the petitioner have failed in performing the contract work for disposal of the garbage, and the performance was not satisfactory, which is in violation to the terms and conditions of the contract. The petitioner was therefore requested to execute the work with full satisfaction as per the terms and conditions of the contract. Otherwise, necessary steps would be taken as per the contract agreement. Subsequent thereto, on 28/30 October 2014, the petitioner was informed by the chief medical superintendent,
Yes.
/LMG, that the contract between the petitioner and the respondents would be terminated with effect from 31/10/2014 for unsatisfactory performance of the work. The record reveals that on 12/3/2015, the petitioner wrote a letter to the chief medical superintendent /LMG that a contract in question was terminated with effect from 31/10/2014. And in view of such termination, the petitioners incurred several expenses for carrying out the work as mandated in the contract and had incurred heavy losses, which the petitioner is entitled to be reimbursed for the work already executed and expenses incurred before the termination of the contract. The petitioner therefore sought for reimbursement of the said expenses, which included the performance guarantee money and earnest money. Report further reveals that on 24/2015, the Chief Medical Superintendent LMG informed the petitioner that the earnest money and the performance guarantee have been forfeited. The petitioner thereupon submitted a representation, and what is the date of this?
My lords, it's undated.
46. Thereupon, the record reveals that a representation was submitted by the petitioner, which is undated. Be that as it may, on 7/3/2022, a legal notice was issued to the respondents herein for refund of the amount as claimed by the petitioner in the representation dated 12/3/2015. This legal notice was replied by the respondents via the communication dated 17/3/2022, wherein it was mentioned that letters were issued to the petitioner time to time from the office for improving the performance and executing the contract in terms of the contract agreement, which resulted in termination of the contract due to the petitioner's failure to improve the performance. Further to that, it was mentioned that as the contract was terminated due to unsatisfactory performance, the performance guarantee money, EMD/security deposit was forfeited in terms with clause 13A, 13F, and 13G, Roman 3 of the contract agreement. It is seen that thereupon the petitioner has approached this court by filing the writ petition on 28/7/2025. The record reveals that pursuant to notice being issued by this court on (14/8/2025), no affidavit filed.
My lords, they have filed an affidavit.
The petition has been filed by the respondents. Stating, thereby supporting the termination and it was mentioned that the railway administration have issued communication on 3 occasions to the petitioner on 9/7/2014, 9/9/2014, and 28/10/2014. Informing the petitioner that the petitioner have failed to perform the terms of as per the terms of the contract. It was also mentioned that the railway administration had strictly, in consonance with clauses 13A, 13F, and 13G Roman 3 of the agreement, forfeited the earnest money as well as the performance guarantee. No reply thereagainst has been filed by the petitioner.
My lords, I was about to, but they have not furnished the annexure which they have annexed with the affidavit.
There is no annexure to the affidavit.
Yes, my lord, they have marked an annexure. They have annexed, they claim that there's a performance report.
No. In your thing, here there is no annexure.
Exactly, my lord. Even in my copy, there is no annexure. If I may draw my lord's kind attention to para 7.
No problem. Don't worry. Not been filed. This court have heard the learned counsels appearing on behalf of the parties and have perused the materials from record. The record reveals that the petitioner herein was granted a contract on 25/7/2024.
14, my lords.
14. Giving effect from 1/7/2014 to 30/6/2016. The record further reveals that the petitioner failed to comply, carry out the work to the satisfaction of the respondent authorities. And resultantly, the contract was terminated with effect from 31/10/2014. The petitioner claimed certain amounts on account of performance guarantee, earnest money, and certain payments to which the petitioner was entitled to by the communication dated 12/3/2015. The record further reveals that thereupon certain representations were submitted. 15. Thereupon, a legal notice was issued on 17/3/2022. 7/3/2022, which was also promptly replied by the respondents, stating inter alia that the petitioner was not entitled to any amount. The writ petition thereupon was filed on 28/7/2025, claiming the said amounts. It is the opinion of this court that the petitioner, that the instant petition suffers from delay and laches. This is a clear case of negligence. At the outset, it is the opinion of this court that the instant petition suffers from delay and laches. Taking into account that the contract was terminated as far back as on 31/10/2014, and the entitlement, if any, ought to have been claimed, and if not granted, the petitioner ought to have approached the courts. The petitioner did not approach the court, rather, after a hiatus of more than 10 years, have approached this court. In this regard, this court finds it very pertinent to take note of the judgment of the Supreme Court in the case of the Chennai Municipal Metropolitan versus so and so, wherein the Supreme Court observed that a person observe that a case that observe that a Kumbhakarna or a Ripven Venkel is not entitled to a litigant who behaves like a Kumbhakarna or Ripven Venkel would not be entitled to any discretionary remedy. On this count itself, it is the opinion of this court that this court, the instance with petition, is required to be dismissed. In addition to that, this court also finds it relevant to take note of that the claims are made by the petitioner is based upon a termination, is based upon the legality or validity of the termination. The record reveals that the petitioner was given notices for improvement, which the petitioner had failed. And it is under such circumstances that the contract was terminated with effect from 31/10/2024.
14.
As to whether the termination was done in accordance with law, as to whether the termination was proper or not, the same would involve a question of tendering evidence and involve an adjudication of the facts, which under no circumstances can be adjudicated under Article 2 to 6 of the Constitution. Accordingly, this court does not find any merit in the instant petition for which the writ petition is dismissed. However, in the facts of the case, this court is not inclined to impose costs.
Obliged, my lords.
For admission, item number 13.
It can be taken up to item number 13.
With this lordship, I'm on behalf of the main counsel, Mohammed Shamin Uddin. I was instructed to take an adjournment for 3 weeks. Since we have received the death certificate of the petitioner only yesterday, so we have to implicate his wife as a petitioner. So
The petitioner died,
yes, in the month of December.
so you need to substitute.
Yes, his wife.
You have to file a substitution application.
Yes, so kindly grant us 3 weeks time.
It has been submitted that the petitioner expired on
December, in the month of December.
month of December
12th of January, my lord. 12th of January, my lord.
2026.
2026.
It has been submitted that the petitioner expired on 12th of January 2026. And the petitioner would be, and therefore, the legal representative have approached the councils for filing an application for substitution of the petitioner. Some time is therefore sought for filing the appropriate application. This is the matter of when are you filing it?
My lord, in the second week of April.
Why?
My lord, we need to get it done. Then we have to go to Nagaland also to file it, my lord. They're from Calcutta, my lord, in a district called Bakuda, West Bengal.
So?
My lord can fix any day as my lord thinks fit.
Stop. Let's something. It has been submitted that the application will be filed by the first week of April 2026. List the matter in the second week of April 2026.
For admission, item number 14.
Your lordship, similar prayer.
For admission, item number 15.
Yes, Peter, Emil.
Lordship, I was appointed on the 6th June 2023. Since my initial appointment, the department is here to pay salary, Lordship.
Lordship, if this matter can come up next week, Lordship. The leading counsel, she is on court number 1 and court number 3.
Mr. Jimome, we have issued notice as far back as on 25/8/2025. Till date, there is no affidavit filed. A person is working out there from 9/6/2023. 3 years have almost passed. Very serious. How is a person going to work? You're working as
driver lordship.
driver. What to do?
Lordship, since I'm not in this matter, and then
Don't worry. We'll have it after some time.
Lordship.
Time being.
For admission, item number 16.
Yes.
Also, in this case, I'm representing respondent number 5, Lordship. I'll be filing my affidavit on Thursday.
Regarding matter pertaining to,
Also, the petitioner is challenging the decision of
well, let the petitioner say.
Lordship.
Yes, what is it?
Lordship, here the petitioner is aggrieved by certain actions taken by respondent number 4 and 5.
We're challenging some order, letter, 3/3/2025. What is that letter? Yes, what is it? Why are you challenging this?
Lordship, here I've published in the newspaper some article and then
So,
being aggrieved, the respondent number 4 and 5 has
while
excommunicated.
defamation case, what is this repetition to do? Huh? How can this be done here? Not possible. Is it possible, Mr. Sankam? I've never heard of these type of matters.
My lord, here the petitioner, being the principal of Heaven Seminary, Dimapur, he had wrote an article in our language titled so and so. He shared a few thoughts about the Christianity in Nagaland, in the soil of our Naga, for which action was initiated against the petitioner by
Why?
respondent number 4 and 5.
Who is respondent number 4 and 5?
4 is Chungdia Village Council. 5 is New Chungdia Village Council.
So therefore, this is a case of defamation.
Yes, my lord.
At best,
And-
as a case of defamation or anything which has been done. How a read court will look into this?
And my lord, I'm appearing on behalf of state respondent number 1, 2, and 3. By
you-
order 1, rule 10 of CPC, our presence here should be deleted because no action was initiated by the
Understood.
state
You have
responsible.
nothing to do.
No.
You have been unnecessarily dragged.
Yes, my lord.
Madam, withdraw with liberty to approach the appropriate forum. Not this way. Or dismiss. Either of. You see, there is any letter written. I've read the letter of 3rd of March 2025. There's a letter written that kindly he will issue another publication out there saying that he is sorry with all these things, what have I done. Thereupon, another letter is written by you that you see, I have written my thoughts out there. If anybody has an objection, they may come and tell me. I will iron out all the issues out there. This is what you have written. Thereupon, they say that they have taken some action against him. Who has taken? That council where the state respondents have nothing. Go before the civil court. Do whatever you feel like. But not this court. How can this court issue a writ not to issue or give you anything to the effect? Recall retract the impugned proclamation with apology to the petitioner by publishing recall. What have you done? What did the response number 5 do? 12/8/2025. You are appearing for Mr. Jameen?
Just want to remind of Village Council of Tunkia Unison.
Why have you done that?
What respondent number 5.
What jurisdiction you have?
The role is very limited, Lordship. The
Then why
petitioner is
you
a citizen of my village,
Why
Lordship.
are you making this? He has written a letter out there. You have any problem with that? You take it out. You also say something that this is not. Why you are asking, taking action against the petition?
The decision was taken by respondent number 4, that is Chunkia Village Council, Lordship. I'm
Who is
representing
he?
5. No,
Who is appearing for Chungtia Village Council? Yes, why you are doing all those things? Village Council is a part, is an establishment made under the Village Council Act.
Yes, Lord. Everybody, Lord.
Do you have that power? It is under what act? Village Council?
Village Council Act.
Let's see the Village Council Act. Does they have the power to look into these things?
Page 60, Lord.
8,
60, Lord.
60.
60.
Nagaland Village and Council Act. So this is the power exercise under 14.1. 14.1. Why you are not going there? I'm not granted a stay also. What has happened now? In the meantime, yes, tell me. Huh? Your senior is not there.
Yes, Lordship, if this matter can be listed on Thursday.
Your senior is also not there.
Yes, Lordship.
The counsel for the petitioner, as well as the respondent number 4, counsels for the petitioner and the respondent number 4. 6 for an accommodation on the ground that the counsels leading the matters on behalf of the petitioner as well as the respondent number 4 is not available today. This matter on 19th March 2026.
Lordship, there is an interim.
What interim? I didn't grant an interim. No interim business. What is there? You go and participate out there.
For admission, item number 17.
Here, please, Your Lordship. Lordship, here I received an instruction and I'm preparing my affidavit. So kindly grant me 3 weeks of time to file my affidavit.
What is the standing out there in the compassionate appointment?
Lordship, here she's in serial number 11.
You'll consider when his term
Yes,
comes. Matter over. We dispose it off.
Lordship.
Respondent number 4 has received the application on 8th month on any grateful on the comparative event and during the submission. Inform to submit as all cards and the survey. Next is on the question of giving the fees for the person being residential. According to so you are at serial number 11. Your turn will come, then we'll get it. In the meantime, you submit the succession certificate, Aadhaar and non-employment certificate. Okay. Heard Ms. So-and-so, the land counsel appearing on behalf of the petitioner. Mr. So-and-so who appears on behalf of the respondents. The petitioner herein is aggrieved by the non-consideration of the petitioner in terms with the office memorandum dated 17/9/2015 and the addendum dated 9/4/2019. It is the case of the petitioner that the petitioner father, late Imti Sang, was appointed by an office order dated 17/5/2010 on contract basis as VFA veterinary field assistant and posted in SPBC Merangkong under the establishment of the district veterinary officer, Mokokchung, Nagaland. Thereafter, the petitioner's father was promoted to SVFA on 10/6/2022. Subsequently, the petitioner's father was regularized by an order dated 3/5/2012, passed by the additional director, Directorate of Veterinary and 2012. How is it possible? By an order dated 3/5/2012 by the passed by the additional director, Directorate of Veterinary and Animal Husbandry, Nagaland. The petitioner's father expired on 22/8/2025, leaving behind his mother and 4 sisters, along with the petitioner. The petitioner thereupon submitted an application on 3/9/2025, seeking consideration for appointment on compassionate basis in terms with the office memorandum dated 17/9/2015 read with the addendum dated 9/4/2019. You are also the said the petitioner's representation application being not considered, the petitioner therefore has approached this court by filing the present writ petition on 14/10/2025. This court, by an order dated 16/10/2025, issued notice. Today, when the matter is being taken up, Mr. So-and-so, who represents the state respondents, have placed an instruction dated 4/12/2025. The said instruction is kept on record and marked with the letter X. From a perusal of the said instruction, it is seen that the petitioner, upon submission of her application on 8/10/2025, was asked to submit the succession certificate, Aadhaar and non-employment certificate, which the petitioner is yet to submit. Be that as it may, the petitioner has been placed at serial number 11 in the waiting list in terms with the office memorandum dated 17/9/2015. It is also mentioned that the petitioner would be entitled for appointment on compassionate basis in terms with the office memorandum dated 17/9/2015. When her turn comes and she cannot be appointed on compassionate grounds without submission of the documents, that is the succession certificate, Aadhaar and non-employment certificate. The learned counsel appearing on behalf of the petitioner submits that the petitioner would submit these documents at the submit these documents. For taking into account the above, this court therefore disposes of the instant writ petition to consider the case of the petitioner in terms with the office memorandum dated 17/9/2015 upon submission of the succession certificate, Aadhaar and non-employment certificate, which are required for being considered in terms with the office memorandum dated 17/9/2015. It is further observed that the petitioner's entitlement will only arise at a time when the entitlement would be strictly in terms with the office memorandum dated 17/9/2015.
For admission, item number 18.
Yes.
The petitioner husband was appointed as a painter helper way back on 27/3/2003. Then he joined on 29/3/2003 under STO Oka.
So you are claiming under what?
Well, the wife is.
Where is the impugn letter? 21/10/2025.
Four zero, my lord.
48. 48.
We are trying to see that because of necessity, whereas the question of the me is not the issue in the present petition.
So you are relying on the other one.
No,
Justice Robin Fukon's judgment.
in Isangla. Page 9-6.
What is this judgment? Why Annexure 17? What is this? What are these judgments we have? Prem Singh.
Prem Singh, yes, but whether it is work charge, skill up pay or contingency, it should be counted for the pension.
But you have to be regularized first.
Malok, Prem Singh is very clear whether somebody is in.
How can be a person dead be regularized?
Malok, this is for family pension, Malok.
Huh?
Family pension.
Understood. As of now, that person concerned was not entitled to.
Malok, as per Prem Singh, they are entitled. It doesn't have to be
Prem Singh
regularized.
understood, Mr.
Malok.
Mr. I understand Prem Singh, but the thing is, Prem Singh was alive. Wasn't Prem
Well,
Singh?
what the principal principle is that whether it is contingency work charge, it will be counted for pension.
Understood. First, pension will come once you are regularized.
Malota, what I'm saying
Unless
is
he is
that
not regularized.
it doesn't have to be regularized.
Yes, he has to be. Because you see, a person who is outside the scope, he has to be brought within the services of the state. That is regularization. The person who is outside is being brought into the services of the state. Now, this person died in the year 2019. At that time, when he died, he did not claim regularization.
Malota, the principle has been written in page 96.
90?
96.
Yes.
This also was tie in harness.
But this is okay. This is a single judge. Now you have the judgment of Justice Amasa in that Nisibi judgment.
Nisibi is it was solely on the ground of delay.
No delay. The question is that person concerned during his lifetime never applied. Never. One. Secondly, even if it is looked into, he was not entitled to regularization at the time when he died.
Not.
That is Nisibi.
When it is a tie in harness, the scheme will not be applicable.
Yes, it would be.
No.
Yes, it would be applicable if he has done.
The question will be when it is a tie in harness.
Just for
serving personnel will be a question of regularization in seniority. But when somebody die in harness,
provided he completed the 30 years, na?
No. It is a family pension. It is not the service pension for the serving personnel.
So a person who dies, he may get the benefit.
No. That is what
a person
I'm
who does
saying.
not die, he won't get the benefit. How is it possible?
One of the scheme, what the government tried introduced is that when somebody completed 30 years, he will be regularized. Fine. That is as far as for the serving personnel. Otherwise, this is also could have been come under that if he was alive. But when it comes to somebody dying in harness, it is the family pension, not under 49. It will be under 44, 54.
He was appointed when?
2003. 27/3/2003.
And he was given the scale of pay on.
From the D1, from the D1.
Ah.
From the date of appointment.
Is it?
Yes. He was in the scale of pay.
So you rendered 16 years of service,
My lord,
isn't it? How many years? 16 years.
16 years.
So what was your age at the time when you died? Where's your death certificate?
My lord, that I have not verified.
That is very relevant. Date of birth 77.
Page 34.
77 at the time when you died.
Page 34.
You were in 2019 you died.
Page 34.
77. So here is 23
No,
plus
you are in
19.
page 29.
You died at the age of 42. Huh? At the age of 42.
But that I have not inquired.
No, your date of birth is 1977. Page 23. Isn't it? So 77 is 23 years plus 19 is 42. So you had another, you worked for how many years? 3 to 19, 16 years. Plus another 20 years. 10 years left. As on date also, you would not complete 30 years.
No.
No, if the person was alive. No, my question is.
If we go by.
No, Mr. MT.
54.
No, Mr. Longchel.
54.
No, my question is. You died in the year 2019. Your
The
job.
deceased died. The petitioner is to wife.
The deceased died in the year 2019. He joined in the year 2003.
My lord.
16 years? 16 years.
That does make I've not looking.
No, I'm asking you.
My lord.
This 16 years. From 2003 to 2019 is 16 years.
My lord.
After 14 years, he would have been entitled to. As per 17/3/2015. 30 years. You need minimum 30 years.
My lord, what I'm trying to understand, I'm trying to interpret is.
I understand.
Yes.
But as of now, you cannot, if you are alive also, you are not entitled to these 14 years. You don't complete 30 years. Do you?
What I'm
You will complete
interpreting is
you would complete 30 years in 2033.
Mother, that aspect of the matter I understand.
No, my question is, as of now,
because
because of the person died, how can you be regularized?
My lord, what I'm bringing is only for the family pension because somebody died in harness.
Family pension is possible if you are brought within the service.
So
you are not regularized.
Prem Singh is very clear that for pension, contingency or work charges should be counted for pension.
Understood. But he is regularized.
My lord, that is what I'm saying. It doesn't have to be regularized. No.
Let us see Prem Singh.
Prem Singh is very clear on that.
Let us see where it is. Yes. Yes, where? No, Mr. Longcho, kindly appreciate one thing. The period when you are working as a work charge is to be taken as a qualifying service for your pension. There's no quarrel with that. There's no quarrel with that proposition. But the fact that you have to be regularized to get the pension.
Well, no, that the same principle can be applied.
No.
When somebody have died.
How do you know that he will be regularized? That he will complete 30 years? He may withdraw. Prem Singh says that that period of work charge is to be counted for the purpose of pension.
So the principle is clear on that.
Yes, there's no quarrel, but he has to be brought within the service.
When the principle here,
no, a work charge person cannot get pension normally unless he is brought within the service.
My lord, that is what I am praying.
You are asking for
I'm asking for a direction of this honorable court that this is service, let it be contingency or work charge, which is very clear. Should be counted for pension.
Understood, but first he has to be regularized.
My lord, when the Supreme Court is very clear on that line, there is a question of passing an order in line with the Supreme Court direction.
Where is that direction?
The direction is that this should be counted for pension.
Definitely. Pension is only given to regular.
My lord, Prem Singh is very clear by the Supreme Court that it should be counted. Let it be contingency also.
Just for example, Mr. Longsel, let us take the example that this person is regularized today. And from today and tomorrow he retires. The period he has spent as a work charge would be counted for his qualifying service for the pension. There's no quarrel with that proposition. But unless he is not regularized or brought within the services of the state, how can he get pension? My question is. What do you say, Mr.
Exactly, my lord. My lord, basing on that, that representation.
Anyways, this is a new matter. Let you file your affidavit.
Lordship.
This is a law. And this being the second round of litigation, why you are not filing an affidavit?
Lordship, we'll be filing.
This is the second round of litigation. In as much as in the previous round of litigation, there was a direction in the year 2019 inasmuch in the previous round of litigation, that is in the year 2019, there was a direction passed by this court by an order dated 23/4/2021. This is the second round of litigation. In the earlier round of litigation, by an order dated 23/4/2021, passed in WPC number 80/2021, this court disposed of the said writ petition, directing the respondents to consider the representation submitted by the petitioner on 4/9/2019 in accordance with the law within a period of 2 months from the receipt of the certified copy of the order. In pursuance thereto, an order was passed on 21/1/2025, whereby the petitioner representation was rejected on the ground that her husband having expired in the year 2019, there cannot be a posthumous regularization as it is not the policy of the state. It is under such circumstances the petitioner has approached this court again by filing the present writ petition. The record reveals that this court, by an order dated 16/10/2025, had issued notice. 5 months in the meantime have elapsed, but no affidavit in opposition is filed. Mr. V. Jimomi, appearing on behalf of the state respondent, submits that within 2 weeks the affidavit in opposition would be filed positively. List the matter on 9th of April 2025. In the meantime, the affidavit be filed on or before 6th of April.
Not 8 or 9.
Huh?
It may be some other later date. 8 or 9 is my constituency by election.
Now let him file the affidavit.
My lord.
And 9th, let your junior be there.
My lord.
And if I am not there, I don't trouble. Other judges are quick.
Much obliged.
For admission, item number 19.
Yes, what is this?
Lordship, this is a compassionate appointment. Case. I have received this list of compassionate.
What is the
waiting
serial
lists.
number?
249.
249, Lordship.
Huh?
249,
249.
Lordship.
When did your mother expire? Mother expired on
My father expired on 16/11/2022, Lordship.
16/11/2022.
22, Lordship.
You are at serial number 249.
249, Lordship.
You'll be considered as per that only. You can't be given before that. That's the policy.
Lordship, Lordship.
Compassionate appointment is absolutely the policy of the state. It is normally in violation of Article 14 and 16, but it being the policy, you have to go as per the policy. So we dispose it of. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. So-and-so appears on behalf of the state respondents. The petitioner herein is aggrieved by the non-consideration of his application for being appointed on compassionate basis in terms with the office memorandum dated 17/9/2015. The fact of the instant case would show that the petitioner's father, late ABC Inglaung Hong, was working as
Constable, Lordship.
constable
Lordship.
in the establishment of the Superintendent of Police Longlang, Nagaland. Unfortunately, the father of the petitioner expired on 16/11/2022, leaving behind the petitioner, his mother, and 3 school-going children. The petitioner thereupon submitted an application on 16/6/2025 seeking appointment on compassionate/humanitarian grounds in terms with the office memorandum dated 17/9/2015. On account of non-consideration of his application, the petitioner has approached this court. The learned counsel appearing on behalf of the respondents have submitted before this court the list of compassionate appointment application as per the date of death received post PNR Office Memorandum Addendum 9/4/2019. It is mentioned that the petitioner's application at present is at serial number 247.
49, Lordship.
49. And the petitioner would be considered as and when his turn arrives. In that regard, the learned counsel had placed before this court the application, the list of applications filed for compassionate appointment as per the date of death, which is kept on record and marked with the letter X. This court duly takes note of clause 5 of the office memorandum.
Lordship.
5.
Clause 5.
Clause 5 of the office memorandum dated 17/9/2015. As well as the of addendum dated 9/4/2019, which stipulates that a compassionate appointment made to Group C and Group D post under the scheme dated 17/9/2015 shall be strictly in the order of date of death, and first preference shall always be given against those who have died earlier and who fulfills all other eligible criteria. It is the opinion of this court that as the appointment on compassionate grounds is a scheme of the government by which the state wishes to provide succor on account of the death of the sole breadwinner of the family, and it being an exception to Article 16 of the Constitution, the petitioner's entitlement would have to be strictly in terms with the office memorandum dated 17/9/2015, read with the addendum dated 9/4/2019. Considering the above, this court therefore disposes of the instant petition, thereby directing the respondents to consider the case of the petitioner strictly in terms with the office memorandum dated 17/9/2015, read with the addendum dated 9 4/2019. As per the turn, as and when the turn of the petitioner arises.
Obliged, Lordship.
For admission, item number 15.
Your Lordship, here I have sent the affidavit for vetting this morning, so if the matter can come up after 1 week.
What is your instruction?
Your Lordship,
Why haven't you paid?
yes, Your Lordship, the appointment order was issued without proper procedure, Your Lordship, without obtaining the.
Then why you are asking him to work?
Your Lordship, he's not working.
No, but
Lordship, I was temporarily attached with an officer, Lordship.
then you file an affidavit to the effect that he's not working. But if he's working out there, then you have to pay. There's no the second option on that. We'll put it that you are saying you have mentioned that, therefore I'm getting time to file it. Ms. A. Ami, the learned counsel appearing on behalf of the petitioner submits that on behalf of the respondent submits that the affidavit have already been prepared and had been sent for vetting to the state government, to the respective state government. This court inquired with the learned counsel appearing on behalf of the petitioner as to why, on behalf of the respondent as to why, why no salary has been paid to the petitioner since the date of his appointment, that is 23/6/2023.
23, Lordship.
Ms. So-and-so, the learned counsel appearing on behalf of the respondent submits that there was irregularity in the appointment of the petitioner, and presently the petitioner is not working. So taking into account the above, it is the opinion of this court that the said aspect, if brought on record, the petitioner would have a right to reply. Accordingly, this court fixes this matter again on 6th of April 2026. Affidavit be filed on or before 30/3/2026 by the state respondents.
Obliged, Lordship.
For admission, item number 20.
May I please, your lordship?
Let's see the rules. Under what rule? Nagaland,
Nagaland village empowering law, lordship.
where is it? Nagaland village. Yes, madam. No affidavit filed.
Your Lordship, on behalf of my colleague Livika, the affidavit is under preparation, Your Lordship. So if this matter can come up after 2 weeks.
Now, what are the disqualifications of Nagaland village and councils?
My lord. My lord, in the Nagaland village empowering laws, it's page 31. We're on the rule 4B.
Community of Public Institution Service Act.
No, Nagaland village empowering laws.
This is under Nagaland?
This under the heading is the part
Development Board.
development rules.
1980.
Nagaland village development board model rules 1980. This is a revised one. So here the respondent does not fulfill the criteria selected as the Village Development Board Management Committee. As
Only
well as-
permanent residents of the village.
Yes, he's not a permanent resident of the village, as well as does not fulfill the majority also. And
Who is appearing for response number 7?
one Rembungulis was appearing. He has made appearance in his file Takarma, but he has yet to file his certificate. More like governments as well, yet to file affidavit.
There is no impugn order.
Lordship, the order is dated 7/11/2025. Impugn order.
Page.
7/11/2025.
Woman representative. What's her name? Response number 7. Edemo Silata, number 7.
Number 7.
He's not a member of that.
No, he's not a member of the village also.
And what is this page 47?
Sorry, my lord.
Of your petition? We approached the district commissioner in that regard. It's come up for the first time, second time.
No, lordship, this is the fifth time, lordship.
No affidavit filed.
Lordship,
No affidavit
not
filed.
by the respondents as well as the state respondents.
Chalo.
Chip,
Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Miss Amy appears on behalf of AME appears on behalf of the state respondents. None appears for the respondent number 7. First, notice was issued in the instant proceedings on 7/11/2025. And the impugned orders have been stayed in the meantime. The respondents, however, have not filed their affidavits. Ms. AME, the learned counsel, appearing on behalf of the state respondent, submits that the affidavit is under preparation and it will be filed within 2 weeks. List this matter again on 27th of April 2026. Interim order passed earlier shall continue till then. The affidavit be filed by the respondents on or before 27/4/2026.
For admission, item number 21.
Applicable, Your Lordship. This matter is relating with the convention of appointment. Lordship, I have received an instruction. The petitioner is in serial number 7 under Kohima district.
Your lordship, 2 persons were appointed, lordship, who has died on commission ground in the department, lordship, who has died before my father. 2 persons were appointed. So as per the first order, lordship, 10/11/2025, lordship, the state was directed to file details affidavit on how many persons were appointed on compassionate ground, lordship, after 25/1/2025.
No. You see, as per the addendum dated 9/4/2019, it will be taken as on the date of death of the person concerned.
Yes, lordship.
Now, in this particular list in Kohima, all the other persons who are above you, the person who died were all prior to the death of your father.
Yes, lordship.
You are at serial number 7.
Yes, lordship.
So you cannot surpass them.
Yes, lordship, but as per the RTA, lordship, 2 persons were appointed, lordship. My father died on 24/1/2022, lordship. And 1 person whose parents expired on 1/10/2022 was appointed, as well as on 13/2/2022 was appointed, lordship.
Lordship, here in health department, medical department, in other department, the whole roster list maintained by the head of the department. But in medical department, they maintained by the district wise, every district wise. So in district, if the vacancy arises, they appoint according to that, not the whole Nagaland. So because of that, Lordship.
So it is done as per district.
Lordship. The rest of the list is here, Lordship. Department which the district maintained, the roster list. They maintain the roster list according to the district-wise Lordship. And when the weekend arrives, they appoint accordingly district. So the last person who have been appointed was completely from the different district. It was from the Jumukidima district, Lordship.
Who were appointed
Lordship,
as per your RTA? But you have not challenged the appointment. Have you challenged the appointment?
no, Lordship,
No.
after I,
You are asking as per 17/9/2015.
Yes,
So it has
Lordship.
to be as per that only. They will
I
appoint you
submitted
when
my-
your sign comes.
yes, Lordship, I submitted my representation on 9/6/2022, Lordship. Thereafter, since even after a lapse of 3 years, there was no positive response. So again, I submitted my
You are seeking appointment in grade 3 or grade 4.
Policy, Lordship.
You are seeking appointment under grade 3 or grade 4.
Lordship, I'm eligible to any post, Lordship, as per my qualification, Lordship. Group C, in
Where is your application?
Lordship, page 20, Lordship, NXJB, Lordship. Lordship, apologies, Lordship. My NXJC, page 21, Lordship.
It will be as per this only, Kohima, your number 7.
Lordship.
Because if you are brought within the others together, you'll be in more difficulties. Just for example, in Mokoksung, there are a lot who are, the person died in 2018, 19. If you were to take your account in Mokoksung, you will be number 6. Now, You go to Kifri. You'll be number one. Because the person in Kifri, is to get is 5/3/2023. You can go there. Or you are in Kohima.
Yes, Lordship.
Huh?
Yes, Lordship.
Kohima, then your case is you're number 7. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. So-and-so appears on behalf of the state respondents. The petitioner herein is aggrieved by the inaction on the part of the respondent authorities in considering the case of the petitioner in terms with the office memorandum dated 17/9/2015. The brief facts of the instant case as it emerges from the materials on record is that the petitioner's father was serving as a packer under the Central Medical Store, deputy director of Health and Family Welfare Department. He expired on 24/1/2022, leaving behind the petitioner and his mother. The petitioner thereupon submitted an application on 9/6/2022 to the respondent authorities, along with all necessary documents for appointment on compassionate ground against the resultant vacancy caused by the death of her father. The said representation having not been considered, and on the other hand, some other persons under whom they claim compassionate appointment on compassionate grounds, having been appointed, having expired after the petitioner's father's death, the petitioner is compelled to approach this, as constrained to approach this court by filing the present writ petition. Mr. So-and-so appearing on behalf of the respondent submits that insofar as the Health and Family Welfare Department is concerned, for the purpose of maintaining the interstate seniority amongst the candidates, it is done on district-wide basis. The learned counsel submitted showing the entire list of the compassionate appointment applications in various districts and submitted that as the petitioner herein comes within the district of Kohima, his serial number, she is at serial number 7. Inasmuch as those above him, their father or mother expired prior to the death of the petitioner's father. In that regard, he has placed before this court the entire list. Put it for everybody. And the said list is kept on record and marked with the letter X. Footnote. It is relevant to take note of that compassionate appointment on compassionate grounds is not a source of recruitment. It is a policy of the state in order to give succor to the family on account of the death of the sole bread earner in the family. It is also well settled that appointment on compassionate grounds is an exception to Article 14 and 16 of the Constitution. Under such circumstances, a person can claim appointment on compassionate grounds only as per the scheme of the government. In the state of Nagaland, the government of Nagaland have issued an office memorandum dated 17/9/2015, whereby conditions have been laid out under which an application seeking appointment on compassionate grounds would be considered. The same an addendum dated 9/4/2019 has been issued in continuation to the office memorandum dated 17/9/2015. In terms with the addendum dated 9/4/2019, it is made clear that the appointment on compassionate grounds would be made in Group C and Group D posts, strictly in order of the date of death, and first preference shall always be given against those who have died earlier and who fulfills all other eligibility criteria. This court have duly taken note of that in the district of Kohima, in respect to which the petitioner had applied, the petitioner is put at serial number 7, taking into account that her father expired on 24/1/2022. The other persons who are above the petitioner, their father or mother expired prior to 24/1/2022. Under such circumstances, it is therefore the opinion of this court that the petitioner would not be entitled to a writ to the extent of giving her an out-of-turn preference, as the same would be in violation of Article 14 of the Constitution. Be that as it may, the petitioner, however, is entitled to be considered in terms with the office memorandum dated 17/9/2015, read with the addendum dated 9/4/2019. Accordingly, the writ petition stands disposed of, thereby directing the respondent authorities to consider the case of the petitioner strictly in terms with the office memorandum dated 17/9/2015, read with the addendum dated 9/4/2019, when the turn of the petitioner comes. You mark this with X, huh?
For admission, item number 22.
May I please, Lordship. My Lord,
From here only, I can see that the instruction most likely would not be legible. Anyways.
My lord, I've received instruction that the petitioner case has been forwarded to the EAC Ong Pangkung. However, the EAC has not submitted the action taken. So, my lord,
What is this?
another 3 weeks time.
What is the case of the petitioner?
Your Lordship, yes. The petitioner is here before this court impugning Lordship excommunication order dated 27th August 2025, Lordship. Now, Lordship, the case of the petitioner is that the issue arises, Lordship, from a loan transaction that is taken from the committee of respondent number 4, Lordship. Now, what has happened is that in the year 2011, Lordship,
Who has excommunicated?
Lordship, it's respondent number 3, Lordship.
Chairman Senso Mudong.
Lordship of Egg Hill Village, Mangmetong Village, Lordship. So, Lordship, yes, the petitioner, now the case of the petitioner is that not he was the one who borrowed, Lordship. And it is not a case where he has defaulted in repayment of loan, Lordship. Out of 2 lakhs that he borrowed, he has already paid more than 15 lakhs, Lordship, over the years. Now, Lordship, we have the Nagaland Money Lenders Act in place, Lordship, which regulates money lending in the state, Lordship. And it is applicable in the entire state of Nagaland, regardless of village, Lordship. Now, Lordship, what has happened in the case is, the law is very clear under the Nagaland Money Lenders Act that to operate money lending business, Lordship, the person should obtain a license first. Then, Lordship, the interest that is collected has to be annual interest, Lordship. Now, some respite is given to the money lenders once they obtain the license. That is, Lordship, as per the prescribed lending
Who is
rate.
appearing for respondent number 3?
No one, my lord.
Lordship, in this case, notice is not been issued to respondent number 3 and 4, Lordship. Lordship, yes, while moving the petition, Lordship.
How can we satisfy somebody's order?
Lordship,
May I
yes.
please, lordship, what happened was, my lord, the respondent number 3 and 4 are the private body, my lord. It's not the statutory body. And they are challenging the action taken by the private body, my lord.
Huh?
Yes. That is why in the last occasion, the this honorable court has given opportunity to the petitioner to submit representation before the state, my lord. That's how the petitioner has submitted.
Lordship, I have citation to satisfy this court on this matter. Because, Lordship, now, yes, respondent number 4, as far as the committee is concerned, is not a statutory body, Lordship. But respondent number 3, which has excommunicated the petitioner and his entire family, Lordship, it is maintainable because, Lordship, they are a part of the, although not comprising of the village council, but it is a KHIL, Lordship. And they have KHIL representative, Lordship.
KHIL is the KHIL appointed on the basis of some statute?
Lordship, the law is not clear on this, Lordship. But we have the Village Council Act, which your Lordship is
Village Council
aware of,
is
Lordship.
different. Therefore, one matter I did not dismiss somebody's matter today.
Yes, Lordship.
I didn't dismiss on the ground that the village council have done, some Chuntia village council have done that. So therefore, we'll be having it on the next Monday or something.
Lordship.
It is it may here in this case, if somebody has done, yes, excommunication is not permissible in this manner, what has been done by this KHIL.
Lordship.
But what is the value of excommunication order passed by the KHIL?
Lordship.
If it doesn't have the authority.
Yes.
It is not a body made under any statute.
Lordship.
It may be at least a body as per the customary law.
Lordship, yes, Lordship. Lordship, yes.
So as per the customary law, would it be a court? No.
Lordship?
Would it be a court as per the customary law? No.
No, Lordship.
So what is it?
My lord, here, in fact, this petition is not maintainable
Lordship,
because state has not taken any action, my lord.
Lordship, allow me to kindly satisfy this court, Lordship.
They're challenging the.
There is an issue, Lordship. This is an issue
No,
about
Madam,
Lordship,
you
yes.
can do one thing. You can very well, you have submitted a representation.
Lordship, yes.
What have you done?
So, Lordship, what has happened is that initially the issue was raised here because this court has on 8/12/2025, Lordship, well, the petition was moved, Lordship, have made an observation while staying the interim order, impugn order, Lordship. This court has given liberty to send
The
representation.
impugn order has been stayed
Lordship, yes.
and no notice to respond number 3.
Lordship, so we have, yes, notice was not issued. So
How is
we
it
have
possible?
intimated, Lordship.
But
We
how
have
is it possible?
intimated.
Tell me. How is it possible without issuing notice to somebody, you stay their order?
Lordship, that's
Is it possible?
discretion of this court, Lordship.
Not
Which,
discretion understood, but how is it possible? Tell me.
no, Lordship, yes, as directed by the court, the petitioner has taken steps.
Do one
Lordship,
thing.
yes.
Let us issue notice.
Yes.
Taking into account that the coordinate bench have stayed it. We continue the stay, but we issue a notice.
Obliged, Lordship.
What do you say?
I leave it to you, lord.
Yes.
In fact,
Because
it is not maintainable, my lord.
without issuing a notice,
Yes.
it is impossible. You can't stay somebody's.
Exactly, Lordship.
My lord, in fact, instead of coming directly to the court, they should have approached the village authority, and they have not done that one also.
Lordship, it was done, Lordship. No formal application. It's
And
not
the-
done in written.
and
But
the-
we tried to resolve the matter amicably, Lordship. For 5 months, the petitioner waited. He's a cancer patient, Lordship. And not only that, because the money was borrowed by him, but his entire family has been excommunicated. And the entire native has been barred from entering his house, Lordship. This is a very serious embargo imposed upon the entire family of the petitioner who has nothing to do with the loan transaction, Lordship. Now, Lordship, this is why, Lordship, yes, this court has given liberty to issue a
Now,
representation.
because of the stay,
Lordship.
the village people are coming to your house.
Yes, Lordship. Now, because now the petitioner has the responsibility to take care of his aged mother-in-law, father, because the wife is from that village. That killed, Lordship. They have aged parents, Lordship. For 5 months, they could not do anything. With the stay, Lordship, somehow they can visit. And these aged persons are in need of attention, Lordship. And not only that, they have interested property there, Lordship. They have to take care. With the intervention of this court, the stay, Lordship, somehow.
Power to excommunicate somebody? Where is the power? When someone has to have the power somewhere.
Yes.
How is it done? Because if I remember a long time back, I was taking up somebody matter. I think Mr. A. Jimomi was there, and on the other side, there was another one. I forgot his name. Then there was an order passed by him. I said that you kindly consider. In the meantime, they did not consider. Then I passed an order, there's nothing doing. It's set aside that excommunication. There's some Supreme Court judgment also on this. You cannot excommunicate like this.
Lordship, yes.
My lord, as per the customary law, they might have taken the decision money. Customary, yes.
Customary law, you can't keep on excommunicating. Is there a Supreme Court judgment on this?
Lordship, that I'm not aware of, Lordship.
I have passed one order somewhere.
Lordship, yes, because this court has intervened in a couple of cases, Lordship, on excommunication. This is one of the leading case, Lordship, Manglima's case, Lordship, where this court has interfered, Lordship. And also there is another judgment, Lordship.
Yes. Yes, this is the case. Santianger and what is it? I now remember.
Lordship.
This was a case, yes, again the Sumpia Village Council, yes.
If I'm correct, Lordship, I think it's a contempt petition with regard to that case, Lordship.
No, where is the other order? This contempt petition. Where is the other order which 21/3/2024 in WPC number 128?
Lordship, I don't have a printout with me now, Lordship.
This is the order
can-
where I said there's nothing doing.
Yes, Lordship. Yes.
You cannot. Here was a case that this person also wanted to contest the election. And when he tried to contest the election, some of the elders said they don't contest. Then also he tried to contest or something. And they excommunicated him.
Lordship, yes.
This is something to the
Yes, Lordship.
Yes. Both of them were appearing, Sentianger and Watijami. Watijami was for that village council.
Lordship, yes.
My lord, that case and this case is very much different, my lord. In that case, it was taken by the decision was taken by the village council.
Understood. So
Yes,
just
here
to
it
remove
is
the village
taken by the-
council is, I think, the village council, as per the Village Council Act, more particularly Section 5, if I'm not wrong, has the power to decide on the social thing. Yes. If I'm not wrong, where is it? 61. See, the village 14, village council constituted under the law in force from the time being shall administer justice within the village limits in accordance with the customary law and uses as accepted by the canons of justice established in Nagaland, and the law in this respect is enforced from time to time. Yes. Power is there.
Lordship,
But
yes.
where is the power for kill? Excommunication is a very serious aspect. But anyways, I think we should notice.
Lordship. And also, Lordship,
Otherwise, why should we disturb Mr. Pom who had nothing to do?
Lordship. Lordship, in fact, Lordship, under Section 22 of the Village Council Act, the district administration, Lordship, be it the DC, ADC, or the ESC, Lordship, in charge of the circle, exercises superintendent, they have the superintendent power over the village, Lordship.
No, but
So-
this is over the village council.
Lordship.
But this is a kill. Kill is different.
Yes, yes, Lordship.
Kill is just a colony, madam.
But you have submitted a representation, na?
Lordship, yes, Lordship, that's why my humble prayer is that, Lordship. Since my learned friend has submitted a document saying that a report is awaited from the EAC, Lordship, let the report be placed before this court on the next date, Lordship.
You submitted the representation subsequent to the filing of the petition.
Yes, Lordship, as directed by the court, Lordship.
Have you brought it by way of an additional affidavit?
Lordship, I have not done that, but I have it's placed on record, Lordship, which this court has also recorded.
Madam, to give us some jurisdiction somewhere.
Lordship,
Hell, otherwise we have no business with it.
Lordship, I can file additional affidavit, Lordship.
So what you need to do is, you need to file an additional affidavit that we have submitted a representation.
Lordship.
In spite of the representation, the DC is not working.
Lordship.
And therefore say that apart from this, I need the prayer for direction upon the DC to comply.
Lordship.
Come up with that, then only it becomes better for us to exercise.
Lordship,
Then we
yes.
can catch hold of the DC.
I will do that, Lordship.
Please do that. But as of now, I think we need to issue a notice upon the respond number 3 and 4.
Yes.
Lordship.
Heard Miss So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. E form appears on behalf of the respondent numbers 1 and 2. The petitioner herein have assailed an order dated
8/12/2025, Lordship. 8/12/2025.
12/2025, by which the respondent number 3 had excommunicated the petitioner. This court duly takes note of.
Lordship, my apology. The impugn order is 22nd
22nd
August 2025. Lordship.
2025. This court duly takes note of the fact that by an order dated 8/12/2025, while issuing notice upon the respondent number 1 and 2, the impugn order passed by the respondent number 3 was stayed. Taking into account that the respondent number 3 order has been stayed, the notice upon the respondent number 3
And 4.
and respondent number 3 as well as the respondent number 4 has to be issued in as much as without issuing notice upon the said respondents, the present proceedings cannot be adjudicated upon.
Lordship.
Accordingly, issue notice upon the respondent number 3 and 4, making it returnable on 4th of May 2026. Steps be taken upon the said respondents by way of speed post
Lordship.
by within 3 days.
Lordship.
In addition to that, petitioner given liberty to serve upon the respondent number 3 and 4 by way of dusty,
Lordship.
routed through the registry of this court and file an affidavit of service on or before the next date.
Lordship.
The petitioner should ensure that the service upon the respondent number 3 and 4 by way of dusty is completed by 6th of April 2026. Full stop. It has also been the learned counsel appearing on behalf of the petitioner further drew the attention of this court that in pursuance to the order passed by this court on 8/12/2025, a representation have also been submitted before the deputy commissioner. Which one? DC? DC,
Lordship,
which one?
yes, to the Chief Secretary and the DC Mokchung, Lordship.
DC Mokokchung.
Yes.
But till date, no action has been informed to the petitioner. It is the opinion of this court that the said aspect be brought on record by filing an additional affidavit. Liberty given to the petitioner to file additional affidavit on or before 27th of April 2026.
My lord, your lordship,
Lordship, that
The past earlier shall continue till the next day.
may I please, lordship, your lordship, may kindly record the instruction place for your lordship, my lord.
I won't. Not today. Let them file it. As of now, she has not brought on record. What did I say? I said that this she submitted a representation is her submission. That you have not taken into action anything. I said that let her first bring on record that. Then only we'll consider, then only you say, I have taken action. As of now, this aspect is not, it's not born here. Let it be born in the case.
Lordship, just a slight correction, Lordship.
Yes.
On 15 January 2000, this year, Lordship, this court has recorded, Lordship, about the representation. In fact, 3 weeks was granted to consider the representation, Lordship.
It's okay. Whether it is done or not, they will see later on. You bring it later on. As of now, no decision has been taken.
No decision, but within
You have forwarded to somebody.
yes, to the EAC, my lord.
EAC, NAC, otherwise I would have no value. It has to be given, something has to be, because the moment I take it, 3 weeks time has been granted to you to consider, means you have not considered. That now pick the matter up on that basis. That there was a direction, there is no non-compliance, so we asked the DC, the why contempt proceeding should not be issued against him. No, I'm telling you.
No, my lord, the order
It
was
is a
passed.
violation of the court's order.
My lord, the court order was passed on 8. and that forwarded on 5 January, within 3 weeks. The matter was forwarded to the EAC.
Forwarded, the court asks you to consider, na? Consider
In
it
the next
either-
reasonable date, my lord.
We'll see when the matter reaches next.
Much obliged.
Obliged, your lordship.
For admission, item number 23.
My lord, here I'm yet to receive instruction, my lord. The calendar with 3 weeks time.
What is the matter about?
Lordship, the matter is regarding non-payment of the bill with the petition.
How will he receive instruction? You are asking non-payment of a bill of the year 2014
Yes, Lordship.
in the year 2026.
Yes.
How will Mr. Form be able to find any document? 12 years. Isn't it?
Yes, my lord.
Shouldn't we dismiss it on the ground that it has been so and so? Notice has not been issued. Should have come up earlier. Let's issue notice here.
My lord, notice already issued, my lord.
No notice issued. No notice.
Notice was issued on 19/2/26.
Hey, give it to him the order and ask him, where is the notice word? Should? Issued?
No, my lord.
Issue notice making it returnable on 11th of May 2026. Mr. E Form accepts notice on behalf of the respondent numbers 1, 2, and 3. Oh, no,
One,
and 2.
1 and 2.
And 3 is who appears for the High Court?
Is Mummy.
He's not there.
Yes.
Not here. Okay. Issue notice upon respondent number 1 and 2. E Form accepts notice on behalf of the respondent number 1 and 2. As regards the respondent number 3, have you seen age, Mummy?
Yes.
Today?
No.
Okay. Anybody else? No. Petitioner given liberty to take steps upon the register, Gauhati High Court, Kohima bench directly. Extra copies of the writ petition be furnished to the learned councils as well as the register, Gauhati High Court within 3 days. The petitioner herein has filed the writ petition seeking a direction upon the respondents to pay an amount of rupees 13,61,915, to which the petitioner claims is due on account of a supply order dated 9/7/2014. The respondents herein are directed to bring on record their stand by filing their affidavits on or before 4th of May 2026. This court though issues notice, but the question of maintainability of the writ petition on the ground of delay and laches is kept open. Take that ground.
Much obliged.
For orders, item number 24.
What is this? Why the matter has come?
Lordship,
Service awaited.
yes, for respondent number 6, my lord.
Who is respondent number 6?
The private respondent.
What do you have to say?
Your Lordship, let the matter be listed next week.
Why? Now, what do you want to do? You have to take fresh steps.
Yes, Your Lordship.
Ms. So-and-so appearing on behalf of the respondents, petitioner submits that taking into account the office note dated 12/1/2026, the petitioner would like to take fresh steps upon the respondent number 6. Taking into account the above, the petitioner is directed to take steps upon the respondent number 6 by way of speed post within 3 days. List the matter upon completion of service upon the respondent number 6. What is there? You are not taking steps and you are enjoying an interim order. What is this interim order business? What is the interim order?
Interval the respondent number 5 not to issue any appointment order to respondent 6.
Huh? Mr. Angami, can't you serve this thing to the respondent number 6? Because what is happening is
Yes, madam.
the post is vacant
Yes,
for the last 3 years. It
yes,
makes no sense. There's a stay.
yes,
What is the stay? They don't appoint him.
yes,
Now you are not appointing anybody
No.
for the last 3 years.
yes.
Are you not finding it difficult that the post of driver is vacant?
Lordship, at one point of time, in fact, the respondent number 6 made an appearance, a brief appearance, but then the
No, one appearance also is enough. Where is it?
Lordship, I think the council has actually withdrawn his Vakladama again thereafter, Your Lordship.
No, he
And
cannot withdraw his Vakalatama. Where is he?
Lordship,
Who appears for respondent? Registry shall reflect the. Oh, Mr. Yangavati was appearing.
was once appearing, then he drew his Vakladama.
History has shall reflect the Yangavati here, then name of Yangavati Langal shall be reflected. You will mention on behalf of here and 6. So respondent number 6 is not necessary to be served. Why did it require? Earlier, Mr. Yangavati was appearing.
Yes,
So
for
it
a
is
brief
not
period.
required. Not required. Okay. Now, write this one, huh? It is seen that service earlier was meted upon the respondent number 6, and a counsel thereupon appeared. Taking into account that the respondent number 6 is aware of the present proceedings, comma, this court deems that the service upon the respondent number 6 is complete, lists the matter for admission on March 23rd, 2026. Interim order passed earlier shall continue till then. We'll finish it off. 23rd.
Lordship. I am obliged, my lord.
For hearing, item number 25.
Hearing. Yes, Mr. Sharma, what is this matter about? 2016 matter, the first appeal.
First appeal.
Civil suit pertaining to?
Pertaining to declaration that the plaintiff village, the recognition to the.
Oh, wait. There is one matter which I have passed
Yes,
over.
now
with the
taking
inform-
message.
Item number, that is the case.
Nine, item number 9.
9. Give me item number 9, that was 9.
Monday, next Monday.
Huh?
I remember, next Monday,
Next Monday? I
Yes.
fixed it.
23rd.
Huh? 23rd, na? Okay. Matter pertain to what?
Indigenous.
Oh, yes, that,
Yes.
yes, please. Just find out Because it appears, Mr. Imsong, from there, the question is continuation. It appears that from your affidavit, more particularly paragraph number 8 and 17, that the office memorandum, the cabinet decision is in a continuation of the 77 decision. Means those people who are there as on 5/3/1963
Yes,
would be
cut off,
duly
that is a
considered.
cut off year.
So
So we can infer that way. But subsequently, that the notification September 2024, it was passed, superseding all the earlier notification. So because of which the petitioner come forward to the court, challenging the notification 2024.
but you are keeping those people.
Yes, yes. This issue is another PL has been filed. Now it comes in a different way. Nagaland Tribal Council, they filed one PL here that their prayers to set aside the 2024 notification and recall 1977, since there is a cutoff year. So
Okay, we'll see when the matter reaches on that day. Okay. Who is appearing for the respondents here? Oh, you are there.
I'm for the respondents.
Okay. What is the case? Let us see.
My lord, this suit is filed by the village, Teleco B village, for declaration of right title interest, recovery of possession, injunction.
Who has filed a suit?
Teleco B village, Chowdhumpura.
Okay.
Their case is this, my lord. The one, Teleco village was the original owner of the land. There, and that land was in the Rangapahar area. And the government issued a notice to take out their land, Teleco village land, for which the Teleco village filed a suit. That they are the village recognized and their possession is to be declared. Accordingly, that suit was decreed. That Teleco village gifted 100 acres of land to the plaintiff village, Teleco B village. Teleco B village, when they are in possession of the land, the DFO and others, they evicted us from the land, saying DFO, Dimapur, Forest Department, Chief Welfare, Wildlife Warden, Rangapahar, they evicted us from the land on the ground that we have enclosed the land of the Rangapahar forest area. Therefore, the suit was filed and the both parties laid evidence. And there, and the case of the defendant is this, that the land is a wild sanctuary land, and that land, we are illegally occupying the land.
So you are still occupying?
No, my lord, we were evicted from there.
Now you say that that land is yours.
Yes, Teleco village is a gifted land.
Is yours.
Yes.
On the basis of the gift being given by the Telugu village for former defendant.
Yes.
Former defendant gave the land to you, so you are the owner.
Yes.
Okay. Now to become a forest, does the Assam Forest Regulation 1891 applied here?
Yes, but that.
This area, it was since Nagaland was at one point Nagaland was under the Assam. So since the Assam time, before the statute, the forests were receiving and perceiving as a Rangapahar forest since Assam time. And after the statute, again.
No, but there has to be a notification under Section 4.
It's all in the
let us see how does the court hold it.
Next, paper book page number 206.
What does the trial court? Where is the trial court judgment? What does he hold? The learned counsel, okay.
Because as per the paperwork, page number 206 is the annexure D.
Section 38 or 1. Yes. Where's the records
Paperwork, page number 206.
of the paper book?
Paperwork, yeah,
Page?
206. This is issued by the government of Assam. 1916.
Then? What is there, Mr. Sharma? You have no case.
No, we have a case because
Whether it falls within this description. If it falls within the description, in view of section
Lord,
7 or 8
description-
of the 1891 Act, your matter is open.
if this description is accepted, then the Telugu village will also go. They are
Maybe, that's a different thing. They have not thrown out those people, it's a different thing. Tomorrow they may thrown out. But the fact that you do not become, if the entire description falls within it, where's the Assam Act of 1891? Some forest regulation. There is a particular method by which it is being done. Once it is being acquired out there, once the declaration is being, final declaration is being made, this is a declaration in terms with Section 17 of the forest regulation. Here will declare the land described in the schedule to be a reserve forest. Then, no case. Rightly, that is the only issue.
Lordship.
To
Lordship
declare-
here,
that is not the only issue, my lord.
No, if that is the case, that you have been evicted. Only question is whether this falls within this land. You have to show, you are the plaintiff to show that it doesn't fall within this.
My lord, the original Telugu village, they have filed a suit. That suit, they got a decree. That land is within this area. And they gifted theirs. If my land is, I have no locus standi to stand, then on the basis of which I filed this suit, that is the Telugu original village, then their right to also go. In that case, my lord.
No, Mr. Sharma, we are not concerned with performer defendant. That is a different thing. My question is, if your land is within the domain of this is the notification. And by this operation of this notification as per the act, that is a reserve forest. There's no quarrel with that proposition. So once it is a reserve forest, there cannot be anybody cannot remain inside. That is section 2 of the Forest Conservation Act. 98.
My lord, here in this case, my lord, that part will not come because the original Telugu village from which I got the land, they are within the area of that land.
Understood. You are trying to say that original performer defendant,
Yes,
they had earlier obtained the decree
yes,
saying that this particular land is theirs.
yes,
After obtaining the decree, they gifted some 100 acres of land to you.
yes,
And this is the 100 acres of land you were in possession.
yes.
So therefore, you say that in view of the decree which has been passed in the case of Telugu village, that is the performer defendant, your land is within that part of the decree.
Yes.
And therefore, the state would not have any jurisdiction over that. That's your case.
Yes, ma'am.
So, but the thing is, this is a statutory notification, 1891 Act.
Lordship,
Yeah,
another core issue is
Yes.
now the appellant gave on asserting that a village, Telugu village B, it seems is a statutory entity. So appeal was filed way back in 2016, and the appellate court, this another appellate court has framed, direction was given to frame another issue regarding the village. The village. So it is become issue number 10. So that issue, whether the plaintiff village, namely Telugu Bir, was formed as per the prevailing customary law and recognized as per the norms as applicable in the state of Nagaland. So that additional issue was framed and finding was given by the trial court and it was negated. There was no village. And in order to form a village and in order to regard as a village, there are so many notifications. 1996 notification is there. So many criteria conditions are there. And the present case, it is a condition of the appellant that particular plot of land, whatever the size, it was donated by the original Telugu village in 2000. And same donation was returned in the year 2004 by the original villagers. So that's the case, and at present.
Now, was the decree which was obtained by the original Telugu village was after taking into consideration this notification?
No.
Then how does it have any relevance?
No, the second.
And that decree was obtained from whom? Against whom?
As government.
Huh?
Government.
And that aspect was never looked into.
That aspect was looked into.
No, that original Telugu village.
Original Telugu village, my lord, we have.
Let us see the decree of the original Telugu village.
Page 173.
Page?
Page 173.
173. Nobody can read this. Who has prepared the paper?
Court, in the court. Original record must be here. Original exhibit is.
Original record is here.
Exhibit 1.
So the performer defendant has denied your case.
Yes.
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 Subsequently,
They
do
say that we have never donated in land.
No, subsequently they have filed evidence and affidavit and exhibited documents that they stated they donated the land to us.
Have you sought for declaration
Yes.
that this sanctuary is the wildlife reserve?
No,
19th, have you sought for declaration as where is the plain?
Our suit for declaration of right title interest.
No, you have to seek a declaration against that document. If it is a part of that land, then you cannot. When did you file the suit?
2009.
Then, well, where is the plain? Let us see. Where is the plain? Place. Declaring plaintiff's land, declaring transporter, appoint survey commissioner to demarcate schedule A land to buyers and. Mr. Sharma, you must have been approached at a very late stage. No? Otherwise, now, if there is a declaration where the land falls within the ambit of a forest reserve forest by a 1916 declaration, and on the basis of which they have evicted you, you have to seek a declaration that this is not a part of that land. Or this notification, so far as this is concerned, is gone. But where is the 1890? No. This is the Assam Act.
No, but to that effect, we filed a writ petition.
Then what happened? Dismissed.
Writ petition was disposed of and directed to file civil suit.
But you have not asked that relief.
But the relief we sought for is declaration of right.
You cannot. You have to ask the document that instrument remains. Till the instrument remains, how can you get any relief? How can a declaration be given in your favor till that instrument remains? I think Mr. Sharma, he is aiding you not for me not to dismiss it today, right now. Not giving me the Assam Forest Regulation 1891. Because Assam Forest Regulation makes it very clear, you cannot. It should have been wrongly framed. Till that declaration remains, and in fact, suit also cannot be filed against it.
No, that suit was actually filed as per order passed in the WPC.
Understood, but
that
then
is,
also
if the court has directed us to file the WPC, then we have no other option but to file this.
Anyways, Mr. Sharma, we take the advantage of a very senior civil lawyer here and ask one question. Something different from here. You find that Assam Forest Legal. Till then, let me also get myself in respect of some other matter. You see, local alert order award which is passed is an award is an interparty between both two persons. Now, in a case where a third party rights is involved, what does it do as regards the award? Let me give you a very simple example. I am the owner of a land or a house. I give rent to Mr. Imsong. And I am very good with you. I file a suit against you. That you see, you are my tenant. And you both of us join together and get a decree out there, not a decree, it's an award before the local alert that you will vacate within 15 days. Decree, that award becomes a decree. Now, if it is a decree which is there, you can go for execution. Now, what does Mr. Imsong do? Can I file a suit? More so, taking into account there is a recent judgment of the Supreme Court in the case of Dilip Mehta, wherein it says that the only way is 226 or 227. Now, if it is a case of 226 or 227,
That is challenged the order of the local Adala.
look at it.
But the right was not challenged.
Huh?
His right, that was has to be challenged.
His right has to be challenged. No, the thing is, he can only move under 226 or 227. This is the order passed by the Supreme Court. Now, if he moves 226 or 227, how does he show that he is my tenant? He cannot.
He cannot.
The only thing he has to do is to file a suit that the award is not binding. Isn't it?
Yes.
That I think so.
Yes, yes.
Because the court says that you cannot challenge the award even in a civil suit. The person actually moved an application under Order 21 Rule 97, 98 and 101, stating that you see this you can't execute. I'm a third party, I have an independent right. And when that application was filed, the division bench of the Madhya Pradesh High Court said that you go there. That is a right forum. That against that the matter came to Supreme Court. Supreme Court said no, an award has it's a very important thing. You cannot challenge it by way of either civil suit or so and so. But I think that you may not be able to challenge the award. There's no quarrel with that. But you can very well file a suit.
Yes.
On the ground that it's not binding on.
Not bad.
Yet he has to prove, because I cannot take it up under 226, whether he has any connection, whether he has no relation. These are things I can't do. Not there. So, Mr. Sharma, what to do? Book is not available. But I think your case is for dismissal. What do you think?
Lordship, my humble submission to your Lordship is to pursue with the order 41 Rule 34.
What? 24 for
Where
what?
evidence on record is sufficient, then the matter has to be determined finally.
No, I will.
Yes.
There is no question of remand doesn't arise.
Even myself, now I'm completing
No,
5
order
years.
41 rule 24, order 21, 41 rule 23, 23A, 25, nothing comes in. Here the simple case is this. First, there is a notification made under the Assam Forest Regulation 1881, whereby the entire land has been become a reserve forest.
Lordship.
If that land is, you have evicted him on the basis of that notification, or subsequent thereto in 1986, 470 hectares of land was made sanctuary. Now, what is this? What is it? A reserve forest? And above that is a sanctuary. To become a sanctuary is much higher.
Lordship.
What is the requirement is much higher. So once it becomes a what you call a sanctuary, you don't challenge that declaration also.
Lordship.
So without that, how is your suit maintainable on this ground? This can be disposed of as a like a petition itself. So, okay, let me come back in 5 minutes. Then I'll dictate it, finish it.
No matter the.
What? You need some more time.
Yes. Because the new punch is raised. by
No,
a
no,
lot.
this is a purely this
No,
matter
that
would
point
have
was-
come before me any day. I would have asked you this.
No, that point was, this point as Lordship raised. That point was never raised by the defendant in trial court. And in fact, this matter was heard by Honorable Judge Koteshwar Singh. And the Koteshwar Singh, who after hearing the both parties, framed one additional issue number 10. Whether the recognition is necessary or not, to that effect, the additional issue number 10 was framed, and it was sent to the district judge district judge recorded evidence and sent the finding of the,
So it was done under order 41 rule 25.
yes.
That is
Therefore,
okay.
this
Those
method.
are okay. These are very things.
No,
But the simple
no,
question
what I want to submit is this. When I argued before the Honorable Justice Kotesh, another point was raised in the mind of the His Lordship. Now again the new question has come.
Okay, what's it? When do you want it then?
Lordship, it keeps on adjourned now, it is 2016 matters. And even I myself, after joining the Government Council, is completing 5 years. When the file is handed over to me, I'm sitting on these files 5 years now. So unless this type of matter is
This is a matter of 25 minutes of judgment.
Lordship,
Not
so it has to be expeditiously.
But he says that new point. But he
No, no.
also knows. If it again comes up before me, it is finished on
Yes,
another
definitely.
25 minutes.
So without further delay, this has to be.
Mr. Sharma is of the opinion that first day, why should I sit till 4 o'clock? Which is normally not the practice in Kohima. Anyways. Got it? Yes. You got the right after the award judgment.
Yes.
In the civil suit.
Yes.
Now kindly see 7. Even from the date of publication, at the time when there is a publication made under section 4, power to constitute notification issued under section 5 of the Assam Land and Assam Forest Regulation, and till the final declaration also, there cannot be any accrual of rights. The bar is contained under 7. But here, declaration is in 1916. And if it is in 1916, the question, under no circumstance any question arises. Matter over there. No land. Yes. And this is done under notification declare whenever following events have occurred, namely the fixed date for 6 years, so the state government may publish a notification in the official gazette specifying the limits of the event, which area. Then extinction of right not claimed, right in respect of which no claim has been preferred under section 6 and the existence of which no knowledge have been acquired by the inquiry, and under 8 shall extinguish unless before publication of the persons claiming them is satisfied so and so there is sufficient cause for not preferring such claim within the period fixed under section 6. Publication and translation of a power to revise acquisition of rights over the region. No right of any description shall be acquired in or over a reserve forest except by succession or under grant or contract in writing made by or with the previous sanction of the state government or some persons on whom such right or power to create such right vested when the notification was issued. Now in 1986, they have published, we made it a sanctuary. Now after the sanctuary, the questioning doesn't arise for anything. Even in a case under the, what you call the 2016 Act, the right to, what is that person's schedule, that act, right of scheduled tribes and forest dwellers, Act 2016, 6 I suppose. There, a limited right is only given to the forest scheduled tribes. Scheduled tribes' rights are being given. This is being done by the Gram Sabha. That is another aspect, which is a totally different aspect, which has nothing to do. Village is gone. The only thing is you may try your luck with that act. Because you see, normally a forest dweller requires 3 generations. Normal. You, me. But Mr. Imsong can get it. Taking, if he belongs to a scheduled tribe, he does not require that. That is the law of 2006. 6 or 16. So that is another way how you may think about it, that thereby claiming. So there are gram sabhas out here by which it is being done. So that is how we would do it. But not this way. This is a case to be dismissed. Dismiss.
So it may be some other day. Some other day so that I can
Next
also
week?
prepare the
Next week?
on the line.
Next week before ready, next week. Monday to start.
Monday to dismiss. It is only to be passed an order. But Mr. Sharma, you only think with your client out there as to whether by virtue of 2016 judgment, 2016 or 6 Act, 6 or 16 is it? That case of that Mizoram judgment which I gave, 6 Act, whether you can still claim some rights, because there even in reserve forest you claim right to forest scheduled tribes and Forest Dwellers Act 2006. 6, I suppose. You see my judgment in the case of Mizoram judgment to কি আছিল? State of Mizoram versus So there is a division bench judgment which I have delivered. There was a case of some land acquisition in Mizoram. Now, in Mizoram, an interesting thing is 88.4% is forest cover. 99.2% are scheduled tribes. The question arises, where will they go? They were therefore in the forest area. Where will they go? Now this act, 2006 Act, categorically says that the horse what is mentioned even in the Forest Conservation Act of 1980, rights still continue to flow under 2006. If you see section 4 of the said act. You may think about exploring that line. That is another thing you may have, but not this suit. This suit otherwise is gone, is no use. We may think about on Monday either to dictate the judgment dismissing his appeal or he may withdraw. Either of it. Hello. Heard in part, leave the matter on Monday. Any more matter?
Yes, ma'am. Next item is also mine, madam.
Okay. Okay, let me come back then.
Okay. itu কি করা যায় করে দিও না লম্বা করে দিও
Mr. We need to reframe these substantial questions of law. I've never heard 11 substantial questions of law. Yes, heard of? Let us see the impugned judgment.
My lord,
Impugned judgment. Where is the plaint?
plain is at page.
Set aside
Page
the
one.
order written by the influencer as well as cancellation.
Page one. Because, let's see, take up the additional copy of paper rules. Additional copy of paper rules was okay.
You are for the plaintiff.
I am a plaintiff.
Section 18 notice given.
Section 18 notice is not.
Your entire case is against an order passed by the respondent, state.
At the relevant time when the suit was filed, that time the CPC is not applicable because it is filed before the Deputy Commissioner's judicial.
Suit was filed when?
What is
2004.
2004.
February 2004. February 2004. And at the time, this even judicial was not bifurcated, but assistant DC was taking up judicial matters and CPC was applicable.
CPC was not applicable. Applicable. Then? Because you are paying court fee also.
Yes.
You filed a writ petition, then you went to file a suit.
Yes, yes. As per direction of the court. Page 54. It is the order first.
Kindly come to paragraph number 18. Paragraph number 18. Paragraph number 21. Because this suit is essentially a suit against the defendant, against the state.
Yes, yes.
But you have made the state performer.
No, not it is not against this gentleman.
No, kindly see paragraph 21. Page 422. You were granted the patta in 1986.
86, my lord. I had purchased it. I had purchased it. And I got granted in 86 months.
From?
I had purchased the land from one Mr. Hansing. Then after that,
Hansing had the patta.
had a patta. And then it was mutated in my name. Transfer. 1986. I took possession also in 1986.
Yes, 21 issues. No schedule.
No, no schedule.
Title suit.
No schedule, actually, we paid for amendment of the plaint to incorporate the schedule, but that was rejected.
So how can there be a declaration?
Declaration can be made because we have another application pending for appointment of Army Commission. Because there are two reports in this suit that were exhibited. Exhibit page 166 and 167. Two survey reports are there. These two survey reports gives that the land occupied by the plaintiff and the defendant is distinct and different. Therefore, the court's figure is wrong in holding that I have no title over my land.
So the survey report says that the land which you are claiming
Yes.
is different from the land which he is
Yes,
claiming.
These two reports are your lordship. You can see page 166 and 187.
My lord, this has never been exhibited, my lord. It has not exhibited. The survey report that they're saying was not an exhibit.
No, survey report by whom?
The one which they're saying there are two survey reports. Only one survey report was there.
Is it a survey under Order 26?
And during the pendency of the trial, my lord, that was.
Is it a survey under Order 26?
No, my lord. No.
Then
They're asking for a commission now after 26 years, my lord. In this appeal last year, towards the end of the last year, they filed an application saying that there should be a survey now. In the second appeal last year.
My lord, I have filed
And that order has been passed, my lord, in January, 19 January, that will be heard together with the appeal.
Now, your lordship kindly see IA Civil 203.
you have filed an under Order 26.
On the order 41, rule 27,
27.
order 26, rule 9, and 151.
Did you file it before the first appellate court?
Never.
First appellate court it was not filed. It was filed before this court. So subsequently, I have stated what is what actually happened. IA 203.
Now, issue number 12. Whether the suit land was surveyed by the competent authority and survey report of the suit land was submitted by survey report dated so and forwarded to the government for approval and issuance of patta by so and so. This is issue number 12.
Yes.
Now, kindly come to page 58. Why is it said that it is not exhibited? It appears to be an exhibit 2.
What should be said? Lordship,
Why you are saying that it is not
no,
exhibited?
they're saying that two survey report. That is a different survey report. One survey report has never been exhibited.
Exhibit 2, P2.
Exhibit 2 is different now. Yes, that is
Exhibit
different.
P2.
That is different.
That is not the land.
That is not the one they're referring to. They're saying there are two reports. One was in 2005, after the suit was commenced, after trial commenced.
But
This
that is not
exhibited. That has not been exhibited. That has not been proved.
This is a earlier one.
This is the earlier one.
This is in
This is when actually, my lord, it's like this. She sought for allotment. Allotment will be given if it's government land. But now in the suit, she's claiming that she has purchased the land. So when this survey report is when she applied for allotment and the survey had gone to survey the land. And they found the land vacant, but fenced by a brick wall. No houses there. The brick wall was constructed by me in 1986. And thus on the survey report, allotment was given. But then when she entered the land, then I came to know, because I don't stay there, I stay in Mokchu. So then I came to know that someone has encroached and has built a kacha house. That's when I made the complaint. And then they made an inquiry and they said, yes, this is already his land. And the allotment was cancelled. The suit was filed. Now in the suit, they're saying, my lord, the land was purchased in 1983. Then why did they ask for allotment? It was purchased. There's no question of allotment, my lord. It's mutation only.
There are two exhibit 14 is the spot verification report, and exhibit 2 is the survey report.
Your DAG number is what? Your DAG number is what?
Mine is Pata number 70, DAG number 172.
The number 70, DAG number?
172.
172.
Yes, my lord.
And what is the area?
Area is 1 katha, 15
One
acres.
15 less.
15 lessons. Okay. And Mr. Sharma, yours?
My DAG number,
May I say it, my lord?
What is Patta number 71?
yes.
That is wrong. 70, my lord. It's not 71.
Okay. Yours is 826.
Yes.
No, my lord. Pata number 1009. Plaintiff 1009. DAG number 1134. 134.
So this was given in 2003.
2003.
And what is the area?
2 katha, 16 lectures.
So it is more than yours.
Yes.
Yes.
In the papers, yes. Yes.
So you have therefore, if his land is surrounded by a brick wall, 1 katha 15 lectures, you have other lands beyond that.
Well, they are, my cases is they are not in occupation of the suit land. They have never gave any brick wall or other thing.
Okay.
That
So you,
did, 16
did you give the brick wall?
I did.
There's a brick wall. There's no quarrel with that. Are you denying to the fact that there is a brick wall?
But the two reports, if your lordship kindly see, the schedule are different. So lordship kindly take up I-203 my petition. That the position will clear.
Your boundary is different from his boundary. Why? Then,
My lord.
you see, kindly come to page 60. There seems to be a boundary given out there. As regards issue number 19, down below, page 60 of the paper book. So the trial court granted a judgment in your favor.
Yes.
First appeal. Matter went to Supreme Court. No. After this, what has happened? The decision. Now, after paragraph decision, para 32, Viruddha Vivakalur's thoughts. Now, as regards the Order 7, Rule 3, it appears to be they have not taken the judgment of Pratibha Singh.
Yes.
Page 117. Wherein it says it is also incumbent upon the state, upon the government, upon the court also to do so, taking into account Order 7, Rule 3, read with Order 20, Rule 6, and there's another provision. No?
Rule 3 is a curable defect, madam.
It's
It can
pure-
be in the execution state also.
Even at the execution stage. But my question is, a defective decree is okay. But here there is no schedule itself given. Can it be done so? When it is a mandate, it is required.
There are Supreme Court decision. Order 7 Rule 3 is a curable defects. It can be rectified even at the execution stage.
That is the Pratibha Singh's judgment, 2003 2 SCC. In fact, it says that it is the court's duty to do it. If they don't do it, and if the court asks them to do it, and they don't do it, then obviously it's a different thing. It may be dismissed. But anyways, that is not the material for the purpose of that. My main question is, how do they take note of the other one? Now, you had a sale deed
Yes,
of 1983.
yes.
That was not stamped.
My lord,
That was not stamped.
not stamped at that time because from home I purchased the land. He was
He was your brother.
a brother and I sold it. In the meantime, after getting possession,
But
I
then
applied to
also,
go regarding
registration was not there.
registration, but the settlement order was passed. My name was mutated in my name. I
Now,
deposited.
that happened only in 2003.
Yes. Even though the
No, your claim is on the basis of earlier your brother set up that Duncan Basti. Then the Gauhati out there, who was there, in 1961 gave that land to your brother, T. Muri. After giving it to you, your brother, the brother initially constructed twice or thrice or through somebody else, it has been constructed. Then later on, it was sold in the year 1983 to you by a sale deed. Then after that, taking into account that earlier there was no patta system, but now the patta system has come later on. You applied for the patta.
yes.
And then the government submitted a report, and on the basis of that, in 2003, the patta was granted to you. Later on, what has happened, when he filed a complaint, it was found that it is amounts to duplicacy. This is the main case. This is a duplicacy, means one patta is there is another on the same land. Now, the question is, the main question which should have been looked into by either of the courts or anybody was as to whether the patta which was issued to him earlier, there's no quarrel that there was a patta. And the boundary of both are same or not. Because if it is same, you come later on. As per the government records, you come later on. You may have any other right, but not on the basis of that document. You are asking for cancellation of that particular document on the basis that this is your land and the patta was rightly issued in
Yes.
respect to this. Problem arises here, therefore, Order 7 Rule 3 comes in very strongly because you have to say that this is the indicated land on which you are doing it. This is your land which was being given, be that as it may. Now, the main pertinent issue which is there is whether the patta which was issued in his name earlier in 1983 or 86, which is there, does it overlap with the patta issued to you? That's all. Why do we need to go into all the other things?
There's one more thing, Malok. They say patta is not applicable. Patta. State says patta system was prevalent since 1961. Their own witnesses, their own evidence witness, plus PW2 says patta system was applicable since 1968.
No,
And another
no, whether witness says or not necessary. Taking into account that the Assam Land and Revenue Regulation
ma'am.
1894,
Yes.
1886
86.
was adopted in 1968.
Yeah, and Lordship, it was there. It's applicable in Dimapur. No, not in other-
it was adopted in 1968.
Lordship, in fact, this was applicable even prior to the statehood in Dimapur area. In Dimapur area.
So if that is so,
And
so
then
at that point of time,
Lordship, there one more fact, pertinent fact, Malok.
no, therefore the only question is the only, you see, this is a case which is otherwise a very simple case has been blown out of proportion. The issue is as to whether the land which has been allocated to him and the land in which you hold the patta or patta which has been issued to him, does it overlap?
Yes.
Once it overlaps, then it is right for them to say that this patta which we have issued is wrong. Now, where is the finding of fact to that?
Lordship, another aspect, my lord.
No,
Let
us not go into all
what
the
I'm
other
saying-
things. No, the moment you,
what-
Mr. Imti, kindly listen. The moment you come to that,
Yes.
the next question you argue is, this is a question of fact which I can't touch under 100.
Yes.
I'm therefore trying to help you out. So
Yes.
therefore, you have to come before this court to show that this is a my land.
Yes, ma'am.
Why are they aggrieved? They are aggrieved because of the fact that they have been issued a patta in 2003.
Yes.
And this patta is being rejected on the basis that in 2000, on the ground of duplicacy, means their patta, which have been issued, is overlaps with the patta of your land.
Yes. Yes.
That is the simple question.
Yes, ma'am.
Let us not go into all this so big.
Yes.
Now, once the patta is overlaps,
Yes.
where is the finding of fact to that effect? Once that finding is there, it becomes a finding of fact unless there is a perversity I can't touch under Section 100. That is what you need to argue. All other substantial questions of law which have been framed,
Yes, ma'am.
all due respect
That is I agree.
to my coordinate bench.
Yes, I agree, madam. I agree. That it is agreed that this
13 substantial questions of law. In fact,
11
during my entire tenure as a judge, I have always, in all cases, I have framed most probably 10.
Lordship,
One each.
One substantial question.
because this was framed as suggested by the appellant themselves in the appeal memo. Lordship,
The problem is we need to reconstitute or reframe this substantial question of
Lordship,
law.
while
with
doing
the
that,
consent
if
of
your
the
lordship intends to do that,
because otherwise it will be a very, very, very long judgment. But the issue is very small. Issue is whether because you have been issued a DAR. You see, the main problem with his case, let me tell you, you have not taken that. He's only saying, set aside that order of duplicacy.
yes,
Declare my right title interest.
overruled.
My land title. Over what land, there is no mention. There is no Order 7 Rule 3 comes in. That is another thing. But most important thing he should have asked, that this land is not a part of my land.
Yes, ma'am.
That is the main question which should have been there. But anyways, it appears in question number 14 or question number, issue number, issue number, because without cancelling your patta,
Yes, ma'am.
how now this is issue number 14, 15, and 19. Issue number 14, 15, and 19, although this is being cropped up, by which it is being taken up. But the main question is you have your patta still remains.
My patta still remains, my possession over the land
So
for the last 16
question
years.
is whether, because you have not also filed the suit.
I'm not filed a suit, madam.
So he is in possession.
Yes, he encroached, and he came in 2003. And
Is
then
he,
there was
is he in possession, Mr. MD?
forced wrongfully, my lord. That is the reason.
Understood.
Wrongfully, there was a status quo not to do anything, but
when was the suit filed?
2004. She came in 2003.
Limitation Act applies in the state of Nagaland?
Yes, my lord, it applies. But
what do you say about adverse possession?
Adverse possession, my lord. No, my lord, that was during the pendency of the suit. During the pendency of the suit, I mean, there was an order to maintain status quo, not to enter, but she has violated that also.
Not to enter, there is an order.
Maintain status quo, I think so.
The status quo means he remains in possession.
But that is illegal.
But you have filed a suit.
There was an illegal possession this was an issue in the suit, man.
It is your suit.
It is no, it is his suit. My possession since 1986 till the filing of the suit by them, madam. And you see, 17 years of possession.
Mr. MT, your basic question is, it is a question of fact now. Where is the finding passed by the appellate court that it does not overlap or it overlaps?
Lordship, there is no, they're saying over the same patta, over the same land, two different pattas have been given, but the land is.
Where is that finding? Show me then. That is the only issue. He has a right of getting patta is a different thing. Let her get whatever we.
Lordship, give me some time, I have to fight.
Anyway, so today we have to adjourn it. It's already 4:30. But we need to reframe, Mr. Sharma.
Right.
Don't say all these things come up when this is not done.
No, but generally the advocate frame.
The only issue, substantial question of law is whether the learned trial court, first appellate court would have dismissed the suit for not incorporating the boundary in the plate, taking into account on the basis of Order 7, Rule 3. 1. Because that is an important thing.
Yes.
1. The second is whether the findings arrived at by the learned first appellate court that the land belonging to the defendant number 3 overlaps with the land belonging to the plaintiff is perverse. These are the two substantial questions of law which can happen. Now both of you agree, I incorporate that and reframe it the others.
Agree?
That is the only way.
Yes, yes.
Sorry, I missed that.
See, there are two substantial questions of law,
Yes.
as I could see. The first is whether the learned first appellate court was justified in dismissing the suit on the ground that the petitioner, the plaintiff, did not mention the schedule of the land in the plaint.
Lordship, she has not dismissed it on that ground, actually. That is not the only ground that she has dealt with. Order 7 Rule 3 is not the only thing.
I also understand. There are many other reasons. The second is whether the findings of fact arrived at that the land of the plaintiff, of the defendant number 3, or land of defendant number 3 overlaps with the land of the plaintiff is perverse. That's all. This is the case and it can be finished off. Not in this manner, having 11 substantial questions. Let's reframe it. We'll reframe it today. We'll hear it some other day.
Whether her land overlaps with my land.
That is the ground on which she has filed the suit.
Yes.
You see why? Because 47/2024 or 2004 order says it overlaps. It's
Yes.
a case of
It's
duplicity.
the same land. That's what it
So therefore, the patta was cancelled.
is.
So therefore, the issue is that. Therefore, his suit was dismissed.
Yes.
So that is the only question of perversity. And the second is as to whether the suit could have been dismissed. Because you see, sometimes what happened, the perversity is there.
Yes.
The second is, you see, why it is called a substantial question of law. Substantial because if a decision this way or that way would change the course of it.
Yes.
Why Order 7 Rule 3 is required to be incorporated is, maybe that is wrong, maybe wrong. Order 7 Rule 3 may be wrong. But the main issue is as to whether it is overlapping. That is the substantial question.
Just two question of law.
One
Whether
substantial.
Her land, the land
One
claimed by the-
substantial question will law will do.
is the same land, which, Lordship, if I may just
One.
for a moment.
No,
Whether the land, which was.
Mr. Counsel, the lesser the substantial question of
Better
law.
better, I know that.
Is
Lordship,
better.
I'm just trying to again, think about the question of law. The land, my land, whether her land, the patta issued to her is my land. So, yes.
I have filed a petition under.
I think your second one will be required because you are asking for a declaration. These are the two. We reframe it. Let us have it. I may not be in a position to dispose it off, taking into account that I have to give time to both sides when I reframe it. But the question is, let my other coordinate judges, they shall be a less of pain. Otherwise, these type of matters will continue to remain. It's otherwise a very simple matter. It doesn't take much time. Heard Mr. A.C. Sharma, the learned senior counsel, assisted by so-and-so appearing on behalf of the appellant, and Mr. Imti Longjim, the learned counsel, who appears on behalf of the respondent number 3.
Respondent number 1 in the appeal.
The respondent number 1. Ms. B. Sikro appears on behalf of the respondent number 1 and 2. 2 and 3. 2 and 3.
3 and 4.
Wait. Respond. Where is the memo of appeal? Memo of appeal, list of dates. List of dates, list of dates, list of dates, list of... Where is the memo of appeal? Got it. You are appearing for 1, and here she appears for respondent number 3 and 4. This court have heard the learned counsels appearing on behalf of the parties and have perused the order dated 19/6/2020, whereby the learned coordinate bench of this court has framed as many as 11 substantial questions of law, have formulated 11 substantial questions of law in terms with section 100(4) of the Code of Civil Procedure 1908. Upon hearing the parties, it is noticed that most of the questions of law so formulated, most of the questions which have been formulated are either questions of facts or would not come within the ambit of a substantial question of law, as it does not, as any decision in such questions would not change the course of the present appeal. Upon hearing, therefore, this court reframes the substantial question of law as hereinunder. Number one, whether the learned First Appellate Court was justified in dismissing the suit of the plaintiff on the ground of not on the ground that in a suit seeking declaration of title over a plot of land, there is no description of the land in which of the immovable property. Number one. Number two, whether the learned First Appellate Court was justified in arriving at a finding of fact, whether the finding of facts arrived at by the learned First Appellate Court that the land wherein patta have been issued in favor of the defendant, respondent number one, overlaps with the patta which was issued subsequently to the appellant is perverse. First, taking into account that the questions of substantial questions of laws which is being reframed, this court grants 4 weeks time to both the parties for preparation of the same and address this court on the next date. List this matter again on any date in the month of June?
In the month of
June or May or June, whatever it is.
June. Well, anytime, but May also we don't have now. Any day. Preferably a Monday one. So that
1 or 8.
Okay, 1st of June 2026 for hearing.
available.
This is it, nothing more.
Yes.
I think some refresher course is required for the civil court judges.
Okay.
Left over? What is this item?
27.
27. Land compensation.
Yeah, please, you said.
Yes.
By law, I'm for responsibility for two. I have yet to file a affidavit of opposition, my file.
Don't file. Why do you need to file? Why you need to file? Who is to pay the money?
He's the necessary party.
Huh?
You don't know. My lord, there's one, we are not the necessary
Who
party.
is the petitioner?
Lordship, I am the petitioner.
What is being acquired?
Lordship, actually, on account of the construction of the two-lane road,
Huh?
on account of the construction of two-lane road, the building which is just located above the road, as a result of the rampant cutting, it affected the soil stability, and that led to developing cracks over my building, the walls, the beam, everything.
So your land has not been acquired?
No, I'm not seeking compensation for the land, but for the property damage on my residential building.
Oh, they acquired some other land and some stone fell out there.
No, Lordship, my building is just located below the two-lane road that passes by. So for the construction of two-lane road, necessary cutting was done. Thereafter, again, additional cutting was also done. I objected earlier, but they went on cutting as a result of.
So why you are moving here? Why not a suit? The only way is by filing a suit. How do we value the compensation?
Lordship, they have compensated actually, Lordship.
To you?
Yes.
Then?
Just 4 lakhs 83, something like that.
You need more.
That I have not accepted.
Understood. So therefore it has to be before the court. Anyways, we will look into this. Another thing is, this is a land acquisition done under what provision? Acquisition? No land of theirs have been acquired.
No.
So the only thing is by way of a suit. If you want more money, you have to prove it. That this is what was damaged. I can't give you anything. I have all the keenness to give it to you, but I can't give it to you. Anyways, filing affidavit makes no sense here. This is the thing where he should go immediately, and time is running out, Mr. Counsel. This is a matter of 2022. We are 4 years down the line. This matter should have been finished up immediately. Tomorrow, if you want, at 2 o'clock, we'll finish it off and pass an order. You go and file a civil suit, and the period during which the petition has been pending shall be excluded while computing the period of limitation. This is the only way you can get it. Because you see, how can I give you? I have to give you only on one basis. You say that you are entitled to 63 lakhs.
Yes, Lordship.
He says you are entitled to 4,80,000. You say I am entitled to 63 lakhs because this part of my house has been broken. Okay, on affidavit. How will I get it done? How will I arrive at that conclusion? There has to be a witness box there. You are to deduce survey report, surveyor coming there. Then I will have to see, okay, the other side cross-examining, all these things. Isn't it, Mr. Nugle? We'll have to do that. So the only way is file a suit. That is
Lordship, my prayer is just two very simple prayer. One is either direction to pay, and the other prayer is to make the estimates of the damages.
They have already given 4,80,000. Then how can I ask them to give something else? Or I have to arrive at the conclusion that their rate is wrong. How will I arrive at? Tell me. Is it possible?
Sufficient years has already lapsed now. Again, if we go
So
by
therefore, these 4 years has to be excluded while computing the period of limitation. You have to file a suit. Anyways, I think I should rise. I see some of the advocates yawning also. I should rise. Anyways, so we can dismiss it tomorrow. Not dismiss it, allow you to go there. Because you see, anybody passing an order, they would never do it. They will come up with that figure only. One has to know else here. Keeping this matter pending unnecessarily, you should have moved it earlier.
Well, for tomorrow, I have my personal difficulty.
Your presence is not required.
My lord, in my case, I'll be out of the station tomorrow.
Your presence is also not required. His presence is required. And I'm not passing an order against you.
Yes, ma'am.
I'm saying that go before the civil court.
My lord.
I'm just allowing him to think overnight what is to be done. Or you want it on Thursday? Think over 2 nights.
My lord, may it be possible on Tuesday?
Tuesday.
My lord.
Tuesday is tomorrow.
Next.
Lordship, I will not be here on Monday, Tuesday, Wednesday.
That is by Thursday.
Thursday.
You have no problem.
Mine.
So then Thursday,
Mine.
let's the matter, list this matter on Thursday. Otherwise I could finish it off
Lordship, if you can do it tomorrow.
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 Okay, tomorrow at 2.
I think 29 deadline passed over tomorrow.
Why? What is the urgency? I've already. What is the matter?
Doing right, so.
Huh? Affidavit files,
Yes, ma'am.
matter dismissal from service. We do one thing. We don't have it tomorrow. We have it next Monday. Let him produce the records.
Good.
You have dismissed how? Disciplinary?
No, this is in regard to land dispute, my lord. Land dispute. I'm
Actually, I can bring them.
This is some dismissal item, something is given. 28.
28, Lordship.
This is for dismissal.
Yes, Lordship, I'm challenging that.
Then?
If it can be listed after 2 weeks, Lordship, because I filed an appeal, criminal appeal against the conviction. Based on the conviction, I was terminated from service, Lordship.
But you have to get a stay on the conviction,
Lordship.
not on the sentence. Then this is done on the basis of that.
Lordship.
So what to do? I think you should withdraw with liberty to file once after the outcome of the year you can approach this court. This is the only way out, because you see, to get a sentence, conviction state is different, which is very difficult to
Lordship. Right. Lordship, 6 for hearing the criminal appeal, which will be heard very soon, Lordship.
Very well.
After
So
weeks,
let us adjourn this for 6 months. Or you let us adjourn this matter, liberty given to you to mention.
Lordship.
List this, Mr. Muajamin, the learning counsel appearing on behalf of the petitioner, submits that the petitioner was dismissed from service on account of a conviction.
Lordship.
An appeal thereagainst have been filed, and the said appeal is presently pending. Taking into account the above, list this the instant writ petition stands adjourned to be listed upon being mentioned by the learned counsel for the petitioner.
Lordship. All right.
What is this?
I'm questioning the order passed by the appellate authority in declaring the my land to be a public land under the Nagaland Eviction of Persons in Honor of Eviction Act.
Eviction?
Yes.
Why?
The state claims my land to
Quash
be a
the
public
impugn order insofar as response number 9 is concerned, holding the land, petitioner's land to be a public land. This is, you are being evicted.
The eviction order has been stayed by the Supreme Court.
State.
Yes.
Okay. We have it on when? Tomorrow or day after?
Tomorrow, my lord. Tomorrow.
Tomorrow?
Yes.
Okay. List the matter tomorrow. None?